Environmental Appeals Board. 1 o'clock, we have quite a few matters on today. Then we also have some housekeeping matters for the committee itself, so we're going to be really conscientious about time today. So if you feel like you're being rushed, we apologize in advance, but we're going to keep close to the time limits that are required by our rules. Mr. McBroom, take it away.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for its regularly scheduled meeting of May 28th, 2025. I am Short-Term Rental Chief Bonnell McBroom, and I will be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as to not disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant may have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. And you can send these comments to strboard@nashville.gov. Documentation supporters or opponents wish to provide to the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on these cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order, appeal a finding of the board under the common law writ of certiorari in accordance with TCA 27-9-101 and following to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order and the appellants have been notified as required by the code. All affected property owners have been notified and the legal notification sign requirements have been met as required by the code. Chairman Caputo, at this time we will see if we have any elected officials present. Seeing none, we'll be ready to go to the first case.
Is Ms. Haley with us?
It's Darrell Haley, 1610 Dr. D.B. Todd Jr. Boulevard. Is the appellant present?
So under your Rule 4B, in a case where appellant fails to appear before the board, the case will be deferred one meeting. That's what you're, yeah.
Were we going to allow them to?
Oh, yes. Yeah. Let's see. It just said they'll be considered absent if they fail to appear within 15 minutes after the beginning of the public hearing.
Okay.
So you do have a 15-minute grace period built in.
Let's not waste
But-
the next 10. But if they show up, we can
Yeah.
discuss what to do.
Yeah. If you see reason to, change your rules for some reason, you could vote to do that in this instance.
Suspend the rules.
Suspend the rules, yeah.
Do we need like a motion to move to the heel, or are we fine to just move on?
I think you'd need a motion to move it, but maybe just wait to see if they appear first.
Do you want to,
Yeah.
I'm sorry, Anne, were you suggesting we wait until we
Yeah.
have 15 minutes to see if they show before we decide to move?
No, I think you should move on with your agenda, and if they do show up and you want to hear them at the end, then you could make a motion to amend your agenda and move them to the end.
But
And agree to hear them
since
today.
automatically moves them if they're
Right.
absent, then we don't need to make a motion at this point.
Right.
Okay,
If they don't show up at all, then it rolls to the next meeting. Yeah.
moving on then. Next is, your mic is not.
Next case is 2025-003-676 Harding Place. Ms. Bass, are you present? Is there opposition present? Seeing none. Okay, the permit application was denied as the property had operated as a short-term rental property without obtaining a permit. This is an RS-10 zone, which allows only owner-occupied permits. This is governed by BL 2024-478, and the board has discretion under BL 2023-136. On September 24th of 2024, Ms. Bass acquired the property at 676 Harding Place. On October the 12th of 2024, the Airbnb website advertisement was posted. October 24th, 2024, there was one documented stay. November of 2024, there were 3 documented stays. December 27th of 2024, Metro's compliance contractor, Groundicus Host Compliance, identified the website advertisement for this property. December of 2024, there were 6 documented stays, and in January of 2025, there was 1 documented stay. The address for this property appeared on the monthly list for February provided by Groundicus Host Compliance of properties operating without a short-term rental permit. On February 25th of 2025, Inspector John Phelps verified the website advertisement was posted and that the property was operating without a STRP permit. The notice of violation was sent to the appellant. In February of 2025, there were 3 documented stays. March 11th of 2025, a STRP, not owner-occupied permit application was submitted. On March 12th of 2025, Inspector Nick Owen processed and denied the not owner-occupied permit application as only owner-occupied STRP permits are available in this RS-10 zone district. On March the 17th of 2025, Inspector Phelps found that the website advertisement remained posted on the Airbnb website, and he made a site visit to the property and posted a stop work order on the front door. Apparently, later that day, the appellant visited our office and talked with Inspector Phelps, who explained the mandatory 1-year wait based on operating prior to obtaining a permit. She explained that she had gotten bad advice from her realtor and only thought she needed a business license, which she had obtained. I verified that the business license was obtained on October 24th of 2024. With the Davidson County Clerk's Office. And this is the same month that the STRP began being advertised and operated. On March 18th, the appellant emailed Inspector David Fravitt to file for an appeal. Also, the website advertisement was removed on this date. March 25th, there was 1 documented stay. The reason the permit application was denied is that when Inspector Owen saw that the application was for a not owner-occupied STRP permit in a zone district which only allowed owner-occupied permits were available, he denied it for that reason. He did not look to see if the property had operated or if it had been cited for violations, as the not owner-occupied permit could not be approved for this zone district. However, If the permit application had been for an owner-occupied permit, it would have been denied due to prior operation, and the recent notice of violation would have been noted. There were no documented complaints on either the SDRP hotline or the hub Nashville.
Great. Ms. Bass, why don't you come forward and sit wherever you like. Does anyone have any questions for Metro before we hear from the appellant? Go for it.
I just have one question for Anne, just to make sure that I'm in the right frame of mind as I'm listening. What should we be considering when looking at this appeal? Because it was denied based on it being a non-owner occupied permit application. But there were documented stays, but that was not the reason for the denial. So if she's appealing the denial, what do we need to be taking into account, or what can we take into account?
Yeah, so I had this question too when I read this file, and my understanding from talking with Mac is that this is an appeal of the wait period due to the initial notice of violation. And that's how I understood this appeal was framed.
That's correct, because the notice of violation had gone out prior to the application being submitted, and so that was already in effect. And I can quote you here from 6.28.030.A5L. Number 2, upon determination by the zoning administrator or the zoning administrator's designee that the short-term rental property is operated without having obtained a permit, there shall be a waiting period of 1 year from that date for such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. So in essence, once the operation has occurred, they're not even eligible to submit an application for a 1-year time period.
Right, so you could consider shortening that time period, although, I guess bracketing the whole issue of eligibility for the permit to begin with.
So it's not material that the wrong application was ultimately filed, because I was questioning whether or not this was actually right.
Right, that's my understanding of how this is framed. It's being framed as a request for lessening the wait time.
Okay.
And so can we consider evidence provided about her residence if she provided it in the application?
That would be a matter for if you lessen the time or when it's determined that an application can be submitted by the board, whether you grant a leniency or not at the time that the application is filed, that will be considered at that point.
Okay, so we just leave that to codes to work out?
Correct, they'll process it just depending on what you all rule here.
Okay, thank you.
We all good? Okay. Ms. Bass, in front of you, there's a little button, and it'll open your mic. There should be a button on there you go. So there's no opposition, right? So we have 5 minutes for you to tell us about your situation. Don't feel like you have to use all of it. And I'm sure folks will have some questions for you. So why don't you tell us about your situation?
I was like, I apologize about my English. I'm from Brazil. I speak Portuguese, but I'm trying to speak English. And
just do your best.
Yes.
I don't think any of us speak Portuguese. Yep.
Okay.
Before you get started, give us your name and your address for the record.
My address or the Harding Place address.
Your address.
My address. My name is Hirasi Rocha Bez. I live in 706 Green Meadow Lane in Smyrna.
Okay. And now can you tell us about the situation? And just take your time.
Okay. So in Smyrna, I listed my house, part of my house in Airbnb. There, we just go to the city and take like a business license and you're good to go. You can list and everything. Smart, I didn't search before here in Nashville. So I thought was just come here and take a license, that was good. It was not. And this mortgage is almost $3,500 in Harding Place. I didn't know I had to permit first before I lived in Airbnb. It was just a big mistake.
Okay.
I don't have
That's fine.
nothing to
That's-
say
it's a
anymore
simple-
because-
Hey, it's a simple but unfortunate mistake. We understand what you're sharing with us. Does anyone have any questions for Ms. Bass? Please.
Hi, Ms. Bass. Did you receive the notice of violation? So like the letter that they sent in, it looks like February, saying that you were operating without a permit?
The day I received anything was the day he came there and put at the door.
Okay.
The note at the door, and the same day I came talk to him.
Okay,
There's a stop work
Right.
order on the door, yeah.
right. I was just looking to see if you had received the notice of violation prior, but no,
No.
just the stop work order.
Yes.
And then did you have any stays at the residence, any Airbnb bookings after the stop work order?
No, I stopped the same day.
Okay, thank you.
I canceled everybody.
I have a question. So I see here that there was the letter that that was sent on February 25th that you did not get, is that right?
No, I did not.
But then you applied for the permit 2 weeks later.
Because I came here and I spoke with him and he advised me what I should do from that time.
And you came here, how did you find out about the permit process?
Because I came here, I talked to Mr., I forgot his name, and he gave me all the information I needed to do this.
I guess I'm looking to find what brought you here to look to start applying for a permit if you didn't think that it was required?
Yeah, I came, I spoke with him and he said, listen, you can appeal. I had no idea what is it. And he explained me what, and he sent me to Alicia. And she helped me with applied for everything.
I guess I'm still trying to find on March 11th, when you submitted a non-owner occupied permit. Why?
Because I came here and talked to him and he
But
said.
why? Why did you come here?
To talk to him because I had a stop sign on my door.
Ms. Bass, I think what Mike's trying to get at is you must have received the notice of violation on February 25th, a letter. You must have received it because immediately afterwards, you applied for a permit. And then there was a stop work order, and then you came in. That's how the dates work out. So I think maybe you're misremembering the dates. You came in here, it looks like, in mid-March, but you had applied, you submitted the application March 11th. There were 3 documented stays in February. February 25th, there was a notice of violation sent to you. So you must have seen that notice or you wouldn't have even applied, right?
The only thing I remember is they see the sign in my door and I come here, talk to him and he said, you go there, take the sign off and you apply for the appeal.
Okay,
I don't remember.
okay. Any other questions? No? Okay, Ms. Bass, we're going to discuss this amongst ourselves. You can return to your seat if you like. You can turn that mic off. And only if we have additional questions for you, we will reopen the public hearing. But otherwise, we're just going to discuss this amongst ourselves, okay? Thank you very much. Anyone want to go first?
I'll go first.
Go.
I think the timeline is clear. I don't want to make a motion right away. I'd like to let somebody else say their bit though as well.
I agree the timeline is clear, and it's kind of I understand that the matter at hand is that she operated without a permit. But there's a secondary matter of why would we grant relief when it's a moot point, because she's not eligible.
If I may, if staff could kind of make sure that the appellant understands that aspect of it. Now, that's separate from what we're considering today, but just so that they can figure out how to best utilize this property they've purchased moving forward.
Yeah.
If staff could please make sure that they understand the eligibility issue as well.
Yeah.
But that's, again, it's not the scope of what we're
Right.
doing today.
Yeah, I think it is hard as a human being to separate that from my mind because this feels sort of like an exercise in futility. But given the fact pattern that we have, given that the appellant canceled all of her bookings when she got the stop work order, it's fuzzy. I agree that I'm confused as to how she even knew to come in before receiving the stop work order. But even assuming that she had received the notice of violation, that was at the end of February. So I would bet that those February stays probably happened prior to the notice of violation. And
There is one document.
yeah, there was
stay in March.
one in March. I've given this fact pattern and not considering things that are not relevant to the appeal in question, I would say if we were looking at this with anyone else, we would offer some type of relief from the 1 year wait.
Yeah, I think laying aside when in fact she did come in, I think there are other mitigators that would militate for me in favor of offering some relief.
Yeah, and given that I get it, but given that she, in another county has been operating an Airbnb,
Yeah.
I would expect some due diligence to happen, but also it's sort of like, well, if it works this way here, we're all in Tennessee, but I don't know. I would be inclined to offer some relief, not because she does have experience operating an Airbnb in another county.
Yeah, I agree with you.
As a fellow human,
Yeah.
I get it, but at the same time, there's no point in offering relief when she's ineligible.
But that's not for us to decide here today, is what I heard from Ann and from Codes, that they'll decide that when she applies.
On purely technical grounds,
Yeah.
I disagree. I
Yes.
absolutely think
Well,
you
we are
right.
allowed to take
I think
everything
you are right.
into account. Correct me if I'm wrong. We're allowed to take everything into account. If you guys want to offer relief so that in 6 months she could be told she's not eligible, instead of 4
Yeah.
months she could be told she's not eligible.
She might-
or 12 months she can be told she's not eligible.
She
then
might move
can't.
she might move in 6 months, she might move in
Yeah.
8 months. You know, I think I don't agree that legally we are able to consider everything. I think we are bound by sort of the four corners of the appeal itself.
Right, that's my understanding here, because, I mean, those facts could change, right? She could move to that address and then submit an owner-occupied permit. So she could come back with that. So I think that the idea is you're just looking at whether or not you're gonna grant any relief regarding that 12-month wait time.
Peachy.
And that's the only question. I know it's a very
Well, then-
confusing, this is a very unusual and
It's
confusing set
unfortunate.
of
Well,
facts
then-
here.
Well, then let's look
Yeah.
at this a little more critically. We're talking about someone who operated without a permit,
Right.
had multiple stays, 6 in December, stays in January, 3 in November 2024, got a notice of violation, which I believe she received, otherwise she wouldn't have known to apply for a permit in the first place, and still had documented stays after it. So I'm not that moved to offer a ton of relief. So, want to make a proposal of what kind of relief you're thinking about?
I will say she did cancel bookings after she was aware that she was after she states that she was aware that she was in violation. And I think that weighs in her favor to me. And she has attempted to come into compliance. I think Councilmember Parker has often talked about how, the goal of the ordinance is to encourage compliance. So given that she is attempting to come into compliance, I would say, yes, there were a lot of documented stays, but the earliest she would have been informed by Metro was in February. And so I would say maybe offer 3 months of relief to give a 9-month wait period.
What is the standard waiting period under PL 2023-136?
A year.
12 months?
Yeah.
Thank you.
I could live with 9.
I could live with 9 as well.
So I'll make that motion, that we find that the zoning administrator did not err, but given the facts concerning the appellant's attempts to come into compliance, the appellant will be eligible to apply for a permit at the 9-month mark.
Question
When are,
before we-
right,
9
when
months.
are we
Yeah.
saying the 9 months?
When does the 1 year start?
Also, do we need to find that the zoning administrator erred in order to?
No.
reach
No.
No, we
this
don't.
question? Okay.
Right, it's
Yeah.
specifically,
Normally,
he did not err.
He did
in
not
the
err.
concurrent relief
We can
design.
offer relief without thinking,
Right,
without
right,
saying
right,
that the
right,
zoning
right,
administrator erred.
yeah.
And normally, we set that starting point, start the clock, at the date of the documented last stay. We only know there was one documented stay in March, but we don't have a date. Is there any way to fix a date?
Unfortunately, not on Airbnb. On VRBO, they list specific dates, but
So I would say then, when the website advertisement was removed, because that was about halfway through March.
That's fair.
So I'll say 9 months from March 18th, 2025.
I don't, hold on, before we vote.
Yep.
I believe in the past, we typically, if there's an undetermined documented stay in a month, we typically assume that it is the latest possible date in that month, right? That's what we've done in the past, and so then it would, based on this, at least my remembrance of what we typically do is that it would start on April 1st.
Yeah,
I know
March
it's only
31st
2 weeks,
did
but-
pop into my head briefly. I wouldn't have a problem with that either.
I'm fine with that. So let's say April 1st, as of April 1st, 2025, given that there was a documented stay in March, 9 months.
Do you mind restating the motion?
I
Since we got a
move
little off track.
that the zoning administrator did not err in denying the permit. However, given the appellant's attempts to come into compliance with the ordinance, we will offer relief such that the appellant can reapply for a permit 9 months from April 1st, 2025.
Second. Can I see a show of hands? And that's right, Councilman Parker's no longer voting, so it's unanimous. Very good. Okay,
May I say something real quick before? I want us to be very thoughtful and careful, however, about the standards that we say we have to clear before we approve or deny a request for relief. I don't want it to necessarily be a part of the record that we felt we had to find that the zoning administrator erred or did not err. I feel like that opens us up to potential appeals.
I think it has to
I
be a
think
part of the
yeah, that is-
motion.
I think it is
It
part of the motion.
okay,
Yeah.
I misunderstood then. Because usually zoning administrator error is what we find when we find that they interpreted,
I said they
So-
did not err.
Yeah.
Yeah.
no. Whether or not that question has to be answered at all tends to
I think it
only apply-
does.
Okay,
Yes.
so-
Yeah.
The nice thing with the new ordinance that gives us the opportunity to give
Got it.
relief, if
Got
we
it.
can say they didn't err,
Got
but
it.
we're still gonna,
Got it, okay,
we're feeling nice today.
all right, I
Correct.
want to
And
make
that's
sure
the-
my brain is working properly today.
Yes, and that's just confirming the yes. It's
Okay,
basically, it
good.
says, if the board finds that the zoning administrator did not err, act in error or arbitrarily, it may modify the penalty in whole and part based on the following factors, and then it lists the
Yeah,
factors.
we need a single ordinance, one
That is a huge issue.
ordinance to
Okay.
rule them all.
So we had a unanimous agreement. Ms. Bass, thank you for coming in today. I'm sure did you follow what was happening? You should really follow up with staff, because even though the 9 months has been granted, the question of eligibility is still on the table, okay? So that hasn't been determined today, okay? So thank you very much for your time. We appreciate it, and good luck. Okay, moving on. Next case is, I don't think my papers are in order here. Is this right? Becker?
the next case is Matthew Miller for 1904 Boscobel Street. The 945 Chickasaw Avenue was
It's withdrawn.
was withdrawn by Metro,
Yep.
and Mr. Becker was withdrawn by the appellant.
Sorry, we did know about that. Okay. Matthew Miller, are you here? Terrific. Come on up.
Is there opposition?
There's no opposition for this case? Okay, great.
Okay,
We're going to hear from Metro first, but just go ahead and have a seat.
The permit renewal was denied as the property had operated as a STRP with an expired STRP permit. This is R6 zone district, which allows only owner-occupied permits. It's governed by BL 2020-187, and the board has discretion under BL 2023-136. January 1st of 2021, Mr. Miller acquired the property at 1904 Boscobel Street. January 10th of 2022, a STRP owner-occupied permit application was submitted. January 26th of 2022, the owner-occupied permit was issued. January 26th of 2023, the permit expired and was extended 30 days for the grace period. February 27th of 2023, the 30-day grace period expired, and the STRP administrative officer, Alicia Buffer, sent an email to the property manager and the owner informing them that the grace period had expired. Property manager replied that they no longer managed the property, and the appellant responded that he did want to renew the permit. It was extended again to receive payment on March the 1st of 2023. January 25th of 2024, the permit was renewed. On January 26th of 2025, the permit expired. The permit expired on January 26th of 2025, and the STRP Administrative Assistant Alicia Buffer sent Mr. Miller an email to his email address of record on January 27th of 2025, which read, "Your STRP for 1904 Boscobel Street expires on 1/26/2025. I'm inquiring to see if you plan renewing your permit this year, and if yes, your 30-day grace period will end on 2/26/2025 at 11:59 p.m. Again, on February 26, 2025, she sent the following. Your STRP for 1904 Boscobel Street expired on January 26th of 2025. Your 30-day grace period ends on 2/26/2025 at 11:59 p.m. tonight. Please contact David Frebbett regarding your expired permit." Mr. Miller was given an expiration reminder on 1/27/25, given a 30-day grace period, and an email informing the grace period would end at midnight on the expiration day of the grace period, to which we received no response. All of this is done as a courtesy, as the ordinance does not require it. There are 3 documented stays in February, followed by 4 documented stays in March. At this point, the following applies: 6.28.030, point A, point 5, point L, denial or revocation of permit, VI2. Upon determination of the zoning administrator or zoning administrator's designee that the short-term rental property is operated without having renewed the previously issued permit, there shall be a wait period of 6 months from the date of such determination by the zoning administrator or designee for the property to become eligible for an STRP permit. On April 1st of 2025, Mr. Miller emailed Inspector David Frebbett asking if his permit could be renewed. In his defense, he explained that in the past few months he had experienced some very trying events that had taken his time and attention, causing him to forget to renew the permit. This would have been fine if it had been in the first 30 days after the expiration date, as the ordinance section 6.28.030A5I reads, "For the STRP that has received no documented complaints to Metro Codes, Police, or Public Works during the period of the most recent permit period, a 30 calendar day grace period for renewal after the expiration of the STRP permit may be allowed by the zoning administrator upon the showing by the owner of reasonable explanation other than neglect or mistake for the delay. However, after the 30-day grace period expires, it no longer applies." The address for this property appeared on the monthly list for March provided by Granicus Host Compliance of properties operating with an expired permit. On April the 7th of 2025, Inspector John Phelps verified the website advertisement was posted and the property was operating with an expired STRP permit. The appeal application had not been completed, so there was no record of it in the system. As a result, Inspector Phelps sent a notice of violation to the appellant. On April 11th of 2025, the appeal was filed. There were no documented complaints for the property on the Hub Nashville or the STRP hotline.
And Matt, can I just check with you quickly? I see that April 7th, they've noted that the website ad was still posted. Were you able to determine if there were any documented stays in March or April?
If I may, if you look at page 179 of the PDF packet, you'll see information from
Say,
March.
tell me again.
4 documented stays in March,
Okay,
no documented stays for April.
okay.
If I may.
Yep.
So I'm looking at that page 179, which looks like the host compliance report, and that looks like it was scraped on April 4th. Do we have something more recent to indicate stays, or is it this version from April 4th that we have?
Madam Secretary.
Yes, sir. So this is the, looks like a host compliance report, and it looks like it was scraped or identified on April 4th, so if there was data about April, we might not have it but.
Councilmember, if you scroll up one page, you'll see that the listing was removed on the 11th.
Yeah, that,
Copy, thank you.
yes, that's the VRBO advertisement, and it reflected no documented stays,
Okay, thank you.
as opposed to the other being the Airbnb.
Thank you.
Any other questions for Metro before we hear from the appellant? Okay. Mr. Miller, thanks for coming in today. You have 5 minutes. There's no objection. There are no opponents here today. So you have 5 minutes to tell us about your situation. And perfect. You're going to start by giving us your name and your address for the record.
Sure, thank you. Matthew Miller, 1904 Basketball Street, Nashville, Tennessee, 37206. For starters, thank you for hearing me and putting me on the docket, and apologies that we haven't even talked about this. This was a big mistake. But I do want to give you a little bit of history, and also, I don't think Clay Cap is here, but I want to give gratitude to Clay. You guys are probably all familiar with who Clay is, but he was kind enough to give me some time and resource around understanding this mishap. So I won't take it back to Rome, but I will give you a little history about the purchase of this house and how it evolved to where we are today. So when I bought this house in 2021, I came here to take care of my parents who were failing. And, you know, they've lived in Nashville and the surrounding areas over the years for the last 25 years. So when I came to town, a lot of my time was distributed taking care of my father, who died in 23, and my mother died last year. So the house was intended to be a place for them to move into. But once I realized that that was not going to happen, I started utilizing it as an Airbnb. What I would say to all of you, if we were in an elevator and trying to explain what happened here, I think it was just a miscommunication and a lot of events and a lot of variables that was a perfect storm. So if I could explain that. If you'll notice on the docket, which you guys did a very good job of documenting everything, obviously, back in 23, I did this also. And the reason I did that, or reason that happened, I should say, is we had it under management at that point. And by the time that the renewal came up, they were no longer the management. So you can see that the email chain led to them, they emailed to me, and then we took care of it. And it was thankfully within that 30 days. In this situation, because of my time limitation, and what I mean by that is the complications and the variables around this, my mother passed, which, you know, unfortunately, if any of you have had that event, it can throw a lot of things financially and emotionally within the family dynamics off. So I have several siblings, some nephews and nieces. My mother was the last of two, so the pillar of the family was gone. And I was also the executor and still am trying to settle her estate. So amidst that, I also brought on another manager who was not aware of this permit deadline. That's on me. So took over another manager. I can't see all the things to the house as I probably would or should or would want to. And so when this notice came up, maybe similar to many of you, I get 50 to 100 emails that I don't care about, junk, spam, what have you. Just missed it. So when I add that to administering the bad email management, bring on a new manager, I also run a company in California where I have to go fly into California and manage on a regular basis. So I'm in and out of town. And so, again, I apologize that we have to sit here and talk about this. I as a homeowner in Nashville and specifically Lachlan Springs, I appreciate this policy. I appreciate this hearing. I understand it. And I have to be very clear. There is absolutely zero intent in me circumventing this. We're going against the rules of the city for short term. And again, I think it was an administrative mistake. Regarding the April stays, I guess there were after the notice, there's two things I'd like to comment about that. We use a product called Wheelhouse that will switch on, and my Raphael Santander, my property manager, if he was here, he could testify to hours on the phone with Airbnb trying to figure this out. So if we switch off the calendar, Wheelhouse will switch it back on. And at that point, we had bookings that at Clay Cap had advised did not need to be canceled, okay? So if you could put yourselves in my shoes for just a moment, I'm looking at this as an administrative problem. Sorry I missed the paperwork, but there's no intent, not trying to circumvent the law. And you guys have seen the reviews in the packet that you have before you. There's no complaints. It's a top 5% property, guest favorite, et cetera. So we have no issues. We didn't think that there was any real big deal here. Well, when we looked at the calendar and Clay Cap and then the summons to appeal, it said cancel everything. And that's $20,000.
Time.
Yeah.
Yeah.
Mr. Miller, I'm sorry, that's your 5 minutes.
Oh, okay.
But we have read your materials, and
Okay.
you may be able to make whatever points you had left if people have questions for you.
Should I remain here?
Yeah, remain there. Anyone have any questions for Mr. Miller?
I do. Maybe it's for legal first. I just want to, is it okay to clarify whether or not Mr. Miller lives at this address, if this is his primary residence?
You can ask, but I think the issue before you is regarding the wait time.
Yeah, I get it, but that sort of leads to another
If it's pertinent
issue with the,
to you understanding
yeah.
the issue, then yes. if it's
Is this your
relevant.
permanent or your primary address, Mr.
It
Miller?
is, yeah.
I'm thinking, sorry.
Okay, no problem.
The thoughts didn't come together fully before. And you brought on a property management company to manage this,
Yeah.
who did not immediately address the fact that the permit was expired, correct?
At what timeline?
You said you
When
recently
the
brought on a new-
notification came in?
Yeah,
Yeah, so it didn't go to his email because he was not managing the renewal. That's correct. Yeah, so it came to me because of the last time. The last time it was with the property manager, so I made sure that it was to my email address. When he took over, it was my mistake to not transfer that notification to him. Being a one-year annual notice amongst emails, it didn't even occur to me, frankly. But yes, he did not receive that notification. Yeah.
Anyone else?
So first of all, I'm very sorry
Yeah,
for
thank you. Yeah.
what you're dealing with. Cannot imagine. As to this, I completely understand things getting lost in email. I forget things all the time. But I am seeing that you did exchange emails with Alicia. I thought you had exchanged emails with Alicia in 2025, like this year. And you said you were waiting for her to send you something, or maybe that was, I think I'm a little confused about the emails that we have in our record, because it looks like you exchanged emails in 2023, which is not sort of relevant to this particular time period, but did you receive, I guess, sorry, did you receive any notification that your permit was going to renew this year?
Eventually.
Eventually
Eventually it
when?
was called to my attention, yeah.
Do you know about when that happened? When it was?
Too late.
Okay.
Yeah. Yeah, and frankly, it was a scrub of emails. I was looking for something else, as I recall.
Right.
I immediately sent it to Raphael, my manager, and he said, I'll take care of it, or I got this, right?
Okay.
And then he said, you're late.
Okay.
And then he disclosed what I guess was rebounded to him, which was it was past the grace period.
Got it.
And then we were, very surprised by the proceedings after that.
Right. And then as to Councilmember Cap and your interactions with him, are you saying that you asked him for advice and he told you not to cancel the bookings that you had?
Yeah, great question. So I was sincerely shocked by all of this. Again, from my perspective, I know I was late, but the intent of the policy, as I understand it, is to catch people that are trying to do this. And this was a missed timing paperwork submission from where I sat. So I said, I don't know who to talk to about this. Looked up my representative for Lackland Springs, and Mr. Cap was available. So what he said was he did a great job of explaining the policy in more detail. He said the policy was written to catch people that are trying to illegally rent homes on short-term rental platforms, right? By not getting a permit and circumventing all of the policies behind that. And that I totally understand. The other thing we talked about is the discretion. So who, if anyone, has the discretion to look at my circumstances? Because I just thought, Clay, I've got to be on the wrong pile here. There can't be, I don't think anybody can look at this and just go, yep, that guy's trying to break the law here, right? Mm-hmm. So he said, let me go make some phone calls. A couple weeks went by. He got back to me over a phone call and he said, two things. That was the other one, excuse me. I said, do I have to cancel everything? That demolishes my Airbnb status. It's $20,000 of income lost or thereabouts. Can you get some clarification on that? And he came back to me and was kind enough to say, hey, I figured it out. They don't have discretion. That's what the appeals board's for. So good for you. Great. Grateful for that. And then, yes, you do not have to cancel your reservations. Huge relief.
Do you have, was this a phone call,
It was a phone call.
email?
Phone
Okay.
call, yeah.
And we don't have anything from Councilmember Cap we didn't receive any
I
correspondence?
did have correspondence with Councilmember Cap, and I explained to him the situation, which basically was covered in the summary that I gave. However, there was no mention of cancellations and bookings.
Right.
And certainly no permission given
Oh, absolutely.
for him
Absolutely.
to inform the appellant
Yeah.
that he need not cancel.
I'm not,
It was just never discussed.
Right.
and I'm certainly not suggesting that he was correct. If he did that, and I'm gonna assume that he did, someone needs to talk to him. Councilmember Parker. Because that makes our job really difficult, given that you do have to cancel those bookings, and he was not in a position to tell you that you didn't have to. Your official documentation from Metro said you need to cancel everything. I do,
And remove
okay.
your ad.
Anyway, this is more for our discussion, but thank you for clarifying that.
I do, in case you want to discuss this with the appellant, Ms. Williams, I want to point out that you said that wasn't relevant, but I think the reason that Alicia's correspondence with the appellant is here is to show that this is not the first time and that there was a
Yes.
grace period that the appellant was aware of,
Yes.
took advantage of last time.
Yes, and I did not mean to suggest that it wasn't relevant to our consideration, just that it wasn't relevant to what happened this year. I was looking through a bunch of emails, so that was on me. Thank you.
Anyone else have questions? Nope.
Actually, it's a curiosity, Mr. Miller. So after you had the first, it seems like there was a lot of surprise after you had the initial exchanges with Ms. Buffer in 2023. and I'm curious to know, did you calendar your expiration date? I'm guessing not, but I kind of want to.
Mr. Bond, it's a great question. Admittedly, I'm not good at these things. That's why I have a manager. And, you know, the communication with the first manager, they breached contract, so I had to let him go.
Right.
And then from there, it's, you know, it's really not something I'm good at. I have a secretary at work. I mean, really, it's like a thing that I afford because of things like this for profession. Yeah.
And to be sure I understand your previous testimony, when you hired the second property manager, you carved the permit renewal out of their duties. That was something you remained.
It was in an outline when he gave his slide deck presentation, you know, but as a actual logistical move that we obviously did not do that because he wasn't aware. So when I sent him the notification, I could dig up the email, was, I am so sorry, right? Because that is his responsibility. That is why he gets paid, but it wasn't done. Got it.
And can I just confirm with Metro, there are no documented complaints about this property, right?
That's correct.
Anyone else have questions? Musings, pithy asides, nothing? Okay,
Can I make comment?
no, we're good. If anyone has a question for you, great. If not, we are going to close the public hearing. You can turn your mic off. You're welcome to stay there, or you can return to your,
Just for our discussion, I wanted to get in the queue.
Oh. Councilman Parker's going first. Thank you very much for your time. We're going to discuss this amongst ourselves. And we're going to start with Sean.
Thank you, Chair. Yeah, on this one, I mean, the basis that we usually use for reducing the weight is kind of steps being taken to comply. We've got, I mean, there's an email from late February, Alicia, to the property manager, and we have 7 documented stays after that period. I can't find a basis for granting relief in this case, personally.
I would agree.
I know that sometimes the services like the Wheelhouse app, that I think other people have mentioned that in their presentations before. I mean, if an app is causing you to violate Metro code, you shouldn't use it. If the app is not compatible with the regulations here, I wouldn't recommend folks use it. But yeah, I can't get around the 7 documented stays after direct communication with the property manager.
Yeah, and I think there was a clearly identified opportunity here to exercise better diligence once communication happened in 2023 and just wasn't taken. And for no justifiable reason based on what I've heard and read. So I tend to agree with Councilmember Parker.
I think for me, this one is tough because I do think there's a justifiable reason that things fell through the cracks, given the circumstances that were described to us. And it's really hard for me when we have a council member telling an appellant something that is not true and giving them bad advice. And I understand completely that is not the official channel. But when you have your council member telling you something, it's
hard for me to find that as a fact, though, since there's nothing other than the testimony of, I have nothing to substantiate that.
The council member is not present to explain the situation.
He's not, but we
so
assume that appellants are, aren't we supposed to assume that they are not lying? Like, if they're lying, then they could be punished for that, right?
They're not testifying under penalty of perjury,
Okay.
but you can, if other evidence were to emerge that brought their testimony into dispute, then that would be a factor you would consider.
When it comes
I don't
to
know
something
why
like
he
that,
would lie about
I
it.
probably require some substantiation beyond just the testimony. And also, the council member is neither an apparent or actual agent of the office, and I think that's something that should be known. It also stands out to me that at the time that communication purportedly occurred, Mr. Miller had Ms. Buffer's email address, so he had access to Metro directly to ask these questions and verify the information that he was being told was correct. Again, that's just another diligence failure that's material to me.
Yeah, and I completely see and do not dispute any of that. I think it's difficult
Sure.
to say, well, I'm just going to ignore what everyone goes to their district council member. Like, that's the first person you go to.
Sure.
Yeah, so I mean, that's all I'll say on
Sure.
this. I think there is, to me, I would support a lessening of the time to reapply, but it doesn't seem like there's an appetite for that on the board, so I'm not gonna make a motion.
Let's hear from this end.
I actually agree with Nicole. I think that we have had multiple cases where we have provided relief based on personal situations.
Yeah.
You know, Mr. Miller discussed losing a parent and the struggles that go with that, and I think that there has to be some grace to that component. But I also think that there's, you know, to what Terrence and Councilmember are saying, there's, you know, conversation needs to be had around responsibility, right? And so I don't think that there's, you know, relief from, you know, complete relief here, but I think that there needs to be some kind of a balance that's put into place.
I agree. I think, you know, going through all of the challenges that I'm having, you know, the conversation with Clay Cap, I think that, at least for me, I'm just going to ignore that and not weigh it either way. And then I also understand having difficulties in life. But then, you know, on the flip side, there were conversations in 2023 about, you know, the way that it should be handled. And then when there's a property management company that comes in, not knowing who is responsible, that also makes it challenging to figure it out. I guess I'm inclined, I don't know personally, you know. I mean, I want to sympathize or empathize with this, but then I also see that there has, you know, there's at least been the opportunity and the knowledge of the process. And there was a time when there were no email reminders going out. And in that time, you know, we usually offered some kind of a relief, but we stood pretty firm that that is a courtesy and not the catalyst for renewing the permit. So I'm still a little torn. Sorry, yep.
Any thoughts on the matter?
Yeah, I was just going to say I do sympathize and empathize with Mr. Miller. I just feel like there is an overwhelming amount of evidence of a lack of management here and follow through on the conversations with Alicia, the various communications, and that's what I'm struggling with. It became apparent at some point that he was aware that he was in violation, and you know, the property continued to operate as an Airbnb, and that's what I'm struggling the most with. If we were in a situation where the listing was removed immediately when he became aware of it, I would feel differently and been more inclined to grant relief. And I'm still not opposed to granting nominal relief, or,
Some relief,
some
yeah.
relief. But
Could we,
What
I'm
about-
sorry,
It's only a 6-month waiting period.
right.
How about we make it 5? For those who don't feel that any relief should be granted, it's barely noticeable. And for those who feel that some relief should be granted, it is some.
I was going to suggest, because I'm sitting here looking at the things that we can consider, and when we decide whether to offer relief, you know, intent, whether the appellant did knowingly commit a wrongful act. I think it's pretty obvious it was not intentional. He's been operating with a permit for several years, no complaints.
I would disagree with that a
Okay.
bit, just because of the prior knowledge of the permit process, the prior conversations, knowing. So, I mean, I think I'm leaning more towards a slip of the mind than a lack of intent.
Okay, for me, those feel like the same thing, but I understand. No, I don't see any injury to neighboring residents. There have been no complaints, so there's no evidence of injury. Undue hardship. So, I mean, this was obviously a self-imposed hardship. So that does not weigh in his favor. Remedial action, unfortunately, he did not immediately correct or abate the wrongful activity upon being notified of the applicable law and the furtherance of public policy, whether the granting of relief will substantially impair the intent and purpose of the code. And I think going back to the idea that the purpose here is to encourage compliance, Mr. Miller is obviously not like a bad actor in my mind. I would be inclined to say 4 months as opposed to 6 months. And so I'm actually just going to make a motion, and we'll see where it goes. So I move that the zoning administrator did not err. However, given the totality of the circumstances, Mr. Miller would be eligible to reapply for a permit 4 months from April 1st, since the last documented stays were in March.
I'll second that.
Can I see a show of hands?
I'm not voting, I wanted to discuss the motion.
Yeah.
Sorry?
I wanted to discuss the motion, I'm not voting.
Okay.
The only hesitation I would have about this motion is, the clearest, most objective basis that we use for granting relief is what people do when they know that they're out of compliance. Again, the goal of all of this is compliance, and I said it before, I'm going to say it again, I'm not seeing efforts at compliance here, and I am not inclined to offer any relief, but y'all are the ones who have to vote on this, so.
Well, also to ensure that we're tight on the law again, and I may be wrong on this, just to make sure that I understand, the code says that it's 6 months from the date the zoning administrator determines that there was a violation. So wouldn't that sort of tie us to the notice of violation issuance date as the date from which we start counting the 6 month period?
They said in the packet, it said that he would be eligible on October 1st. That they were counting from April 1st.
Okay, so the
So
same
that's
month
why I
that
said
a violation issued. I get
April
you.
1st.
I get you.
Not to further muddy the waters, but in the past, we've always considered the posting of the website, which in and of itself is violation, as a violation. And that post was still posted April 7th. So why would we start counting April 1st?
Because that's what code's intended to do. So I wouldn't start counting on a different day than they were intending to count. I wouldn't, but that's.
So I don't understand why codes was counting April 1st if the ad was still up April 7th.
The ruling that we got several years ago, the advice we got from legal was that the stay is what should make the determinant. And each stay is a separate violation.
Right.
And so the last stay is the last violation. That's why we base it upon that. But
doesn't the ordinance say that advertising when you are unpermitted is a violation? You are not allowed to advertise, not just operate, not just have stays, advertise.
That is correct, but the opinion that we got from legal several years ago was that we would not impose a 3-year injunction for just advertisement, that there had to be operation. And so going forward from that, we base it on actual operation. But yes, you're correct, the advertisement in itself is a violation.
I have a question as well, specifically about the website.
So much for the motion.
So according to the docket, the last mention of the website is April 7th, and it says that it was still in operation. Do we know if it's still up right now?
I'd be happy to check for you.
I mean, that's kind of what I'm asking, is it's, right? That's the last thing we have, is April 7th says it was still on. We don't know that it was ever
Doesn't
turned
it
off.
say it was removed April
That's what I'm asking.
11th?
No, the appeal was filed April 11th.
No, I'm looking at the timeline of activity from,
Right, I think that was the page 179 reference we were talking about.
Okay.
earlier.
yeah, or if you're looking at
179.
this specific case summary, it's on page 24. It says listing removed April 11th.
Okay.
Okay, thank you.
But if that wasn't the final activity, I think it would be pertinent for us to know.
Right, it doesn't say that there were any documented stays in April, so it looks like documented stays in March. All I'm saying is, I'm keeping my motion as it is, because that's when codes intended to start. That's the advice that they've been given, so I'm saying 4 months from April 1st. But that's, I'm one vote, so maybe we could vote.
Do we think the motion is fresh enough that we can vote on it?
I can restate it.
Restate it.
Okay.
That'd be great.
I've moved that the board find that the zoning administrator did not err, but given the totality of the circumstances, we offer 2 months of relief so that the appellant may reapply for an STRP permit 4 months from April 1st, 2025.
Second.
Nice. Okay.
Okay. It has been seconded. We know what the motion is. All of those voting members, let's see a show of hands. We have tie.
Well, I think you need to call for the noes.
So let's see those hands again. We're seeing Phil, Ramon, Nicole voting yay, and that's right, people might be abstaining. Can I see a show of hands voting no? Okay. Shall we have a motion to consider a different number?
I won't be making that motion personally, because I don't think that, I stand by the motion that I made. So if someone else wants to make the motion, that's fine.
Chairperson.
I move, yeah.
The question that was asked, the advertisement is not up, and it has not been up since
Okay.
April the 7th.
Let's see if we can put this one to bed. I move that we find that the zoning administrator did not err in this case, but with the totality of information, we move to offer some relief, and we shave 1 month off of the waiting period, which will begin April 1st. Do I hear a second?
Second.
Can I see a show of hands of those who are comfortable with this motion? So we have 4, we have Mike, we have Ramon, we have Terrence, we have Julie. So can we see no's? I don't know if we need no's, but yes, there we go. So the motion carries. We have a 5-month waiting period beginning April 1st, and that is reflected. Do we need to do anything about the motion that was a tie? We've never had a tie before.
No, it just failed.
Okay.
I don't,
It just
yeah, I mean, I wish
fails for
maybe
a
we
tie.
pulled this into the motion. I don't know about April 1st. I think April 11th.
Well, the motion was April 1st and it passed.
Yeah,
so.
I know. Okay.
And that's what, look, the only reason I sided with the April 1st was because that's what legal had advised zoning in the past, was based on stays. I get your point. I made your point. So, okay. That was not easy, but it is decided. All right, Mr. Miller, thank you so much for your time, and you can consult with staff, and they will take care of you. Okay, next. I'm sure. Okay.
Our next case is 2025-007, 4329 Cato Road. The appellant is Cameron Daniel. Permit renewal was denied. The STRP is no longer the principal or primary residence of the owner appellant. This is an RS-15 zone district, which allows only owner-occupied permits. This is governed by BL 2020-187, and the board has discretion under BL 2023-136. On June 29th, 2021, 4329 Cato Road was acquired by the appellant, Ms. Cameron Daniel, who stated on the deed it was a single woman at the time. March 3rd, 2023, an owner-occupied permit application was submitted. On March 29th of 2023. The owner-occupied permit was issued. March 25th of 2023, a request for service, or otherwise an RFS, was received on the Hub Nashville. The only comment left on it was the link to the Airbnb website advertisement. I reviewed the advertisement and found 2 violations. On April 28th of 2023, I sent a notice of violation for advertising the whole entire home and for permit number not displayed in the website advertisement. On June the 1st of 2023, the advertisement was corrected and I closed the case. On June 6th of 2023, an RFS was received on the Hub Nashville, and the comment was short-term rental complaint description. Owner does not live at the property and lists the whole home. Inspector John Phelps reviewed the advertisement and found that the whole entire home was not being advertised. He researched the claim that the owner did not live there and was unable to substantiate it. On July the 19th of 2023, Inspector Phelps closed the case. On August 19th of 2023, the appellant, Ms. Daniels, married Brandon Blake Hammond, who lives at 2659 Sporting Hill Bridge Road, Thompson Station, Tennessee, 37179. Mr. Hammond acquired this property on December the 19th of 2016. March 25th of 2024, the permit for Cato Road was renewed. On September the 20th of 2024, another RFS was received on the Hub Nashville. The comment was short-term rental complaint description, owner does not live there, full-time Airbnb. The RFS was mistakenly assigned to Property Standards Division of Codes. The inspector that investigated the RFS made site visits and did not see STR activity. On October the 15th of 2024, he closed the case. On March 5th, 2025, on or about this date, the renewal affidavit was submitted for the owner-occupied short-term rental permit for 4329 Cato Road. And the affidavit listed the owner as Cameron Daniel with the home address as 2659 Sporting Hill Bridge Road, Thompson Station, Tennessee, 37179. It also listed the same name and address for the contact or responsible party. We looked back at the renewal affidavit from the previous year and found that the affiant's name and address as Cameron Daniel, 4329 Cato Road, Nashville, Tennessee. However, the contact or responsible party was listed as Blake Hammond, 2659 Sporting Hill Bridge Road, Thompson Station, along with his phone number and email address. This led us to investigate further. The appellant's Facebook page revealed that she and Mr. Hammond were married on August 19th of 2023. It states that she lives in Thompson Station, Tennessee. The appellant's Instagram page, which is private, notes that she's Noah's mom. The property at 2659 Sporting Hill Bridge Road, Thompson Station, is pictured in the summary package. Mr. Hammond's Facebook has a cover picture from the wedding and states that he lives in Thompson Station, Tennessee. Miss Daniel Hammond's voter registration is addressed at 2659 Sporting Hill Bridge Road, Thompson Station. Williamson County Election Commission records show that she voted on October the 16th, 2024 at that location. The Tennessee Secretary of State has a listing for Cato Properties, LLC, for both the principal office and the mailing address as 2659 Sporting Hill Bridge Road, Thompson Station, Tennessee. Mr. Hammond's voter registration is addressed at 2659 Sporting Hill Bridge Road, Thompson Station, Williamson County. Election Commission records show that he voted on October the 30th of 2024. The Tennessee Secretary of State has a listing for Hammond Medical Distribution, LLC, with a registered agent as Blake Hammond at address 2659 Sporting Hill Bridge Road, Thompson Station, with both the principal office and mailing address as 2659 Sporting Hill Bridge Road, Thompson Station. Mr. Hammond's Tennessee driver's license is addressed at 2659 Sporting Hill Bridge Road, Thompson Station. Inspector Phelps also located a Florida fishing license for Brandon Blake Hammond, which also is addressed at 2659 Sporting Hill Bridge Road, Thompson Station. The Hub complaints for 4329 Cadle Road, of which there were 3 were described earlier in this summary, and there were no short-term rental hotline complaints.
Great. Any questions for Metro? Oh, I think we're going to hear from the zoning administrator.
Hi, members. Good to see you all. I'm Joey Hargis, the Metro Zoning Administrator. I do, in a few of these cases, come talk to you guys, so it's been a minute since I think I've came to see you, and everyone's here at the same time, so it's good to see you all. I just want to remind this board that the things to consider in this are, at the time when this decision was made, based upon the evidence presented to me, were the facts in the case, not subsequent corrections of their record, which I argue points to more in favor of my position that you're not a resident where you say you are. This entire permit scheme functions under some baseline rules that are not written in any ordinance. And it's that spouses live together in a domicile at one place. They don't live separately. They don't live, the husband lives here and the wife lives in a different location. This permit system can't function under that scheme. Otherwise, we'll just have, each married couple has 2 permits. So the baseline in this case is that when staff brought to me the information, again, think of it like a cake. It is, in this instance, voter registration voted at the last election in the county. We look at the residents of where they're domiciled together, clearly in Thompson Station. Although we don't pull tax returns or we don't have access to that, I bet if we were under oath and went through discovery, we would find that they are indeed locked together at Thompson Station. So I guess I'm asking this board and reminding them that it's not just one fact. Think of it as a cake. It's a layer of evidence, publicly available evidence that we use that stacks upon itself. It continues to stack and stack and stack. That we come into at some point, or even like in this instance, the affidavits that the applicants sent in, their own statements listing Thompson Station as a mailing address for them. So, with that, I have nothing further. If you have questions for me, I'm happy to take them at this time. I don't want to take any time away from the appellant.
Could I ask a question?
Of course. You don't need my
Okay.
permission.
So, well, I do. You're the chair.
I don't think you need my permission.
So, I have questions that are not, I don't know that it would be relevant to this case, but I do want to dig into this idea of spouses living together. We've received several times from Alicia this Tennessee Secretary of State guidelines for determining residency, and then what permanently reside means. And it says on here, I don't know where this came from, but it's been sent to us by codes several times. The place where a married person's spouse and family live is presumed to be that person's residence unless that person takes up or continues abode with the intention of remaining in a place other than where the spouse and family reside. So I'm just...
I would happy to talk to you anytime. Anytime
Okay.
like this, members, you're welcome to come speak with me. In this case, there is still good case law in Tennessee, and the name of the second party escapes me, but the case is from the early 1900s at Sumner County. Sued a farmer over the fact the farmer lived in Trousdale County and took his son to Sumner County because Trousdale didn't have any schools. And at that time, Tennessee taxed people not only on their property tax, but they taxed on personal property as well. And it was a dispute over that Sumner County believed that this farmer owed Sumner County taxes for personal property. And long story short, it held out in the court case, even though it's 100 years old, it's still valid law, that a domicile, and forgive the gendered language, but a man has only one domicile. And he has to give that up to establish another with there's no intent to return to the prior place. You can have multiple residences, under that court case. And it actually
Right.
states that, the judge in the case states, it's Dewey, I think it's Dewey versus, or Sonny County versus Dewey.
So then, do you know why we've received this several times that says the place where a married person, spouse, and family live is presumed to be, unless the person takes up or continues abode with the intention of remaining in a place?
I don't know. I
Okay.
mean, I think the presumption's rebuttable. I mean,
Okay.
and that's obviously why Mr. Klein's here, is to rebut my presumption that married couples live together. But I'm just telling you from some baseline rules, and I've been asked it many times, where does it say in the ordinance? Well, no ordinance writes every particular scenario. I mean,
Completely
there have to
get
be
it.
some ground rules.
Yeah.
And one
Yeah.
of those is that married couples domicile in the same place.
Okay.
And you've seen this. You've
Yes.
seen the homestead exemptions in another
Yes.
state.
Yes.
And they're claiming they're here. I guess my point is, if later things have occurred, like, oh, I've moved my driver's license to this location, I've changed my voter registration to that, that's all fine and good when you apply next time.
Right.
But,
And I'm not suggesting that
Yeah.
we take into account anything that occurred
Yeah.
later, but anyway,
yeah, but remember, in
Yeah.
all these revocations, applicants are given 15 days to come see us. Maybe
Okay.
I've got it wrong. Maybe I'm just, whatever I'm looking at's
I wasn't aware of that,
This is
actually.
wrong. We have to give them 15 days of notice before that revocation becomes active.
Okay.
So applicants always have the ability to come see me or my designate, Mr. McBroom, to, hey, show us you've got this wrong. This date is old or whatever.
Okay.
The prior gentleman, hey, so-and-so passed away or whatever. Those are, I'm happy to meet with these folks. It's not just a hammer. 15 days is there. They're just, I rarely get taken up on that opportunity
Got you.
to come here. But they always have a right to come here. Never escape whether they came to me or not to discuss.
Yeah.
That should not prejudice them in front of this board.
Yeah, and I think in my experience with you, you are exceedingly understanding and nice.
And there are some times I can't be, or
Right,
also
right.
not, so.
Okay,
But
That's all I had.
one thing, and I'm sure my lawyer will look at me like, yes, but the fact they did not come see me does not prejudice them in front of you. Please do not let it do so. They have every right to come to this board and disagree with me.
thank you.
All right. And again, if y'all disagree with me, that's great.
I think Mac disagrees with you.
Hey, behind the curtain, sometimes my own staff disagrees with me. We disagree with each other.
Was that anything pertinent that we need to know about?
This one, the state statute regarding, and one thing I'll add, this is the state statute regarding non-conforming uses. And the state statute is 137608 is codified now in state law, but it defines principal residence as the residential dwelling of a natural person in which the person's habitation is fixed and to which whenever the person is absent, the person has a definite intention to return. That speaks to that Sumner County case. There's an intent to return here. If a natural person has multiple residential dwellings that satisfy the definition set out in this subdivision, then the person may only claim one residential dwelling located in this state as a natural person's principal residence. It's presumed that a residential dwelling is a natural person's principal residence if the address of the residential dwelling is the same as the address on the person's voter registration, Internal Revenue Service tax reporting W-2 form from the prior 12-month period. So the state's even telling you, go back and look 12 months. Where are they telling government entities? So for us, to me, that's determinative. That's what this legislature's asked us to do. I can. It's 137608.
60.
It looks like it's 607, 608, and it's probably, looking at this part, Mr. Bond, it's probably in 601, which would be the definition section of that chapter.
607 is coming up something else.
Yeah, what I've got is a copy of the statute pre-codification, the actual deal, so I apologize. But anyway, that's kind of give you a behind-the-scenes thing, and do with it as you wish.
Thank you, Mr. Hargis. All right. I see the appellant is here. Do we have opposition to this case? Ma'am, you're here in opposition of this case? Very good. Okay, so that changes the times that are available to you guys. Why don't you come on up?
If I may remind the appellant, any time that you wish to reserve for rebuttal for the presentation that's offered by the opposition, you will have to reserve from your 10 minutes total time.
Great. And we've heard we've heard what we needed to hear, yes, from Metro. Sorry, Joey threw me off. So everybody's good? We can hear from the appellant? So you know you have 10 minutes. Don't feel you need to use all of it, and reserve whatever time you would like to rebut anything you hear from the opposition. Open with your name and your address for the record, and if both of you are going to be speaking, then you want to make sure you want to get that microphone on. Okay?
Thank you. Seth Klein, 1015 Fatherland Street, Nashville, Tennessee, 37206. I'd like to reserve 2.5 minutes for rebuttal.
Shall we time that for you? We're happy to. Can we do that?
Yes, sir, Mr. McBurn.
That'd be great. Okay, super.
Thank you. Just to address a few matters from the onset and some things that were discussed by Mr. Hargis. First and foremost, I want to note that the appellant did reach out to David Vravitt after this issue came up, had multiple email exchanges. Those are included as an exhibit in this packet. I also had a phone call with Mr. Vravitt and explained the situation and tried to resolve this matter prior to having to file this appeal. So just first and foremost on that. A second point with regard to 13.7-601 and the definition of domicile or place of residency. Mr. Hargis specifically stated that W-2 tax documents from the prior 12 months are indica of a primary place of residence. I have included both the 2023 and 2022 W-2 tax returns, in addition to 6 other documents that are listed on the Metropolitan government website with regard to how to prove residency for an owner-occupied permit. Those are also included in Exhibit 6 to the petition. Lastly, a thing to note is that there are 4 letters of neighbor support included as collective Exhibit 7. Given a brief amount of time that we have today, I will not read from those, but I would please direct your attention to those as you make the considerations today. As you correctly stated, Councilmember Williams, the place where a married person's spouse and family live is a presumption that is, Board Member Williams.
I was like, I got a promotion.
I think I do that just about every time I come here, at least once. Board Member Williams, it is a rebuttable presumption, and it goes back into the following factors that may be considered in bullet point 4. All of which I believe are perfectly and, not perfectly, but explicitly captured in our proof of documentation that we provided. The issue why we're here today is specifically due to an STR renewal affidavit that was filed this year. If you will notice, and as Mr. McBroom pointed out, prior to this specific renewal for 2025 and 2024, the renewal affidavit was correctly listed with Ms. Daniel as the affiant and the responsible party and contact information being her husband, whom she married in 2023. Ms. Daniels and Mr. Hammond both purchased their primary residences separately and apart prior to marriage in 2016, and then later again, Ms. Hammond purchased her home in 2021. As stated in one of the neighbor notice letter or neighbor support letters, Ms. Cameron, after purchasing her home, she approached one of her neighbors, Mr. Chad Raymond, to do the contracting work on the property while she was there. During that 6-month period of getting the house renovated after buying it and moving in, she then applied for her permit. Yes, there was an issue with the advertising, and that was, cited 30 days after the permit was issued and posted. Again, Ms. Cameron Daniels, she rectified that. She mitigated that issue in short order. She was not trying to be bad actress, still not trying to be a bad actor. There was a complaint in 23 that alleged that she was renting the whole home, similar to the 2023 complaint. Mr. Phelps determined that was not the case and also was unable to substantiate that she did not live at the property. Another complaint came in similar to in 2024. Again, that complaint, he did not see any STR activity on the property at that time, and that's because this is not a full-time short-term rental. Ms. Daniel and her husband and now her child still reside there during the week, as I've outlined in our petition. So again, the whole crux of the issue we're here is simply due to a renewal affidavit and subsequently with the voting provision. And I do understand that is a specific, a very material point to this determination by this board. And I know that you will likely have questions for either myself or Ms. Daniel with regard to that and why that occurred. And I'm happy to answer questions or let Ms. Daniel speak to that. The points that I want to make expressly and clearly is that even though there were 3 violations, to be clear, they were not within a 365-day calendar period. These extend for over 2 years, some even 18 months ago. There was one violation within the last, or one alleged violation rather, within the last 365-day period. And again, that case was closed. Lastly, with regard to the record, I just do want to note that with the last points that Mr. McBroom made with regard to the Florida fishing license, Hammond Medical Distribution, Cato Properties, these entities, either one, were all established by Mr. Hammond prior to Mr. Hammond and Ms. Daniel getting married. For instance, Hammond Medical Distribution, that was 2013. There was no dates or issue dates for the Florida fishing license. And it's not disputed that Mr. Hammond's primary place of residence is in Thompson Station. However, in this case, and as we have pointed out in our petition specifically, that Ms. Cameron Daniel has no intent, desire, or otherwise plan to move her primary place of residence from Cato Road to the Thompson Station address. That's the reason why her driver's license still says Cato Road. That's the reason why you'll see 2023 and 2024 IRS W-2 forms stating Cato Road, her life insurance policy, her homeowner's insurance policy, her personal pay stubs for the period December 16th through February 28th. And then AMEX statements from December of 24 and February of 25. I failed to include the January statement. That was my fault. I apologize for that. But all in all, and then in conjunction with the neighbor letters, I understand that there was a scrivener error and a clerical error on filling out this affidavit. That is not questioned. Again, it is not disputed that Mr. Hammond's primary residence is Thompson Station and that they use Cato Road during the week to stay as their primary residence because he works at hospitals and he is oftentimes working very different schedules based on the doctor's schedules and things of that nature. So that is an overall outline of where we're at here. And really the point that I want to hammer down on is I believe it to be incredibly inequitable and unduly burdensome for an appellant to have to abide by laws or ordinances that are not written in the ordinance. So those are unspoken rules. Those aren't good for personal relationships, business relationships, or elsewhere. But when Mr. Hargis specifically states that there are unwritten rules in the ordinance that must be followed, how are we to know those things? In this case, pursuant to the requirements to prove ownership in this capacity, Ms. Daniels has nearly doubled that. And if we take out the voter's registration situation, we will still have 7 of 8 documents. Thank you. I'll reserve the rest of my time.
Very good. Why don't you guys step back so that we can have this young woman come forward, if you'd be so kind. So ma'am, there's a button there. If you're going to press that, it'll open the microphone. You'll see the red light goes on. Okay. Terrific.
Thank you.
You're going to start by telling us your name and your address for the record, and then share your thoughts with us. You have 10 minutes, but please don't feel like you have to use it all.
Thank you. My name is Annie Kinzer. I live at 4253 Hallmark, but I have property at 4234 Edens Creek. And it was really my daughter's house. She's in Atlanta right now. But there's just constantly, I guess, people coming to investors buying property in the neighborhood and in our area. And there's right now, there's a whole lot of properties that are being used as short-term rentals / Airbnb illegally. And especially on the weekends and during holidays, it's just constantly racing up and down the street. There's constantly a lot of parties, a lot of noise, people coming in and out of the neighborhood. You don't know who those people are. You don't know if they're going to come back later and cause some type of crime or whatever. So I'm just totally opposed of this short-term rental, especially if that's not that person's primary property. And I have gone by there, and I have not seen any activity. I don't care what they say. So that's my opposition.
We appreciate your time. Can we trouble you for a couple questions?
Mm-hmm.
But first, can I ask, we're talking in particular today about 4329 Cato Road. Do you have particular observations about that property, or are you talking in general?
I'm just talking in general about the neighborhood, and then I have gone by the property on Cato Road to observe activity there. So that's what I'm saying.
And could you share those observations? Just talking about that specific property, because that's unfortunately really the only thing we're talking about today.
I just went by there just to see if there was anyone actually living there.
And could you tell us your observations?
I could not tell.
Okay.
No. So thank you.
Thank you. Anyone else have any questions before we let you go?
Okay.
Yes, so just to be clear, you don't have any, proof to offer one way or the other, other than, you drove by and you didn't see cars there, or what was
I didn't see cars there, yeah.
Okay, was it during the day?
It was during the day.
Okay, got it. Thank you.
You're welcome.
Thank you so much for your time. We
You're
really
welcome.
appreciate it.
Thank you.
Okay, you folks, come back up. And they have about what's the count remaining? 2.5.
I'll try and keep it at 2:15.
That'd be great.
So just back to the point, I understand that there are bad actors with short-term rentals, and I understand the preservation of a neighborhood. Unfortunately, the testimony today in opposition was not directly related to 4329 Cato Road, so I hope that you will take discretion and use that as you will. Briefly, I just want to touch on a few points of the neighbor letters, because these are from neighbors who are directly across the street, who directly share a property line with the appellant. So, for instance, Mr. Chad Raymond, he's lived next door to Cameron since she bought her house 4 years ago. He is in full support. They have dinner at least once a week at their house. It's become a tradition. Their children play together. Again, this is from 4351 Cato, next door. We have another letter from Kevin Murray, and he lives at 4309 Cato Road, and this is 4329. Again, full support of Cameron continuing her efforts. Another one at 4324 Cato Road, directly across the street, Jonathan Cohn, full support of Cameron getting her permit back. And then another letter from Chris Cadiagani. I'm sorry, I probably mispronounced that. But again, this is not a situation where we have neighbors coming in, especially neighbors that live directly next door, and are saying, no, this is not right. This is not where they live. We don't see these people. And again, pursuant to the state law and pursuant to the Metropolitan Code of Ordinances and what is specifically required under 6.28030.A.B. Roman numeral 4, it's 4 documents. And in this collective exhibit 6, we have 6 documents here. And again, or 7 rather, and I'm taking out the voters registration issue simply because, and again, I'm happy Ms. Daniels or I will answer any questions with regard to that piece, but she simply did it because she had just had a child and she was down there with her family, beginning a new start to her family, a child who was born in the NICU and spent 6 weeks in the NICU. That's the reason why they were in Williamson County. That's the reason why they voted there that day. She was unaware that it was going to have an impact on her voter registration. She's aware of that now. And I've told her that that is the issue that we have to explain today and make clear to the board. And so with that, Ms. McBroom, how much time? I will yield my 5 seconds back.
Mr. Klein, if I may begin. One of your last statements before the opposition came and spoke was that there are certain unwritten rules, we can't possibly comply with those if we don't know. Is it your position then that if there is good case law and also a Tennessee Code annotated provision that speaks to these issues, and Mr. Hargis's contention is that those are what inform their interpretation of Metro codes, is it your position that those are unpredictable?
No, sir.
Okay.
Mr. Bond, may I answer and
Yes,
provide
of
a
course.
response? Board member, it's my position that the controlling ordinance in this case, which specifies the requirements pursuant to Metropolitan Code of Laws and for Metro Codes, who issues these permits pursuant to these rules, these are what the rules say in black and white. And if there needs to be some additional language or color in the Metropolitan Code of Laws that speaks to that, that is an additional requirement or a further requirement, that is, when you go to the website and you click on required checklist for owner-occupied permit requirements, then I believe that information should be specifically listed there if that is what is in the paradigm of laws for Metro that they are applying to these permits. Now, again, but no, sir, I'm not saying that any current precedent in state law that is not listed in the Metropolitan Code of Laws or not otherwise listed on the Metro website is not good law. No, sir, that is not my intent. Okay. It was simply the comment that Mr. Hargis stated that he specifically stated there are unspoken rules to follow. And that, I'm sure, and I have tremendous respect for Mr. Hargis and the job he does. And just, does that sound right? You know, does that, unspoken rules that metropolitan citizens are supposed to follow? That was my point on that.
And is it your position that your client voted legally in Williamson County in October of last year?
Based on the documentation provided in the appellate packet from Mr. McBroom, her address was changed on the date that she voted to thereby make her legally compliant to vote there. From my understanding, and I will let Ms. Daniels speak to this, she was not aware that her voter address was going to change. But outside of that, and with regard to whether or not she was lawfully allowed to vote in Williamson County, based on the documentation I've seen, it appears she was. I did not brief the topic on whether or not the legality of her voting there. I specifically briefed the topic of whether or not we were in compliance with the owner-occupied permit requirements.
Sure.
I feel like we've had this very conversation before about documentation, that, you know, there's a checklist. And yes, you can have a driver's license that lists you at this address and or a voter registration card that lists you at that address, but that isn't the end all and be all. Having those items from the checklist, be it 4 or overachieving and having 6, I feel like we've had the same conversation in the past, right? Was it with another appellant or am I misremembering? But like, that's not the end all and be all, right? That's still open to interpretation and some investigation and some further review by the zoning administrator. Would you not agree?
The case you're referencing, ma'am, is the Michael Serpos case, in which case there was a lease in Miami. There was a tremendous neighbor opposition. There was no neighbor support. While, yes, there was a crux and part of my argument was with regard to complying with the Metropolitan Code of Laws, the circumstances and the circumstantial evidence that surrounded that particular appeal is substantially different.
But back to my question, which was, do you not agree that having followed a checklist and even overachieving what you say you have on that checklist is still open to interpretation?
Certainly, that's why I'm here filing this appeal.
And it's open to interpretation for the zoning administrator. The zoning administrator doesn't need to be satisfied with the fact that you've come up with a driver's license that if you own the home, of course you can get a driver's license at that address. If you own the home, of course you can change a mailing address to reflect that, right? So there has to be something more that the zoning administrator is allowed to do. So to say, hey, look, I checked all these boxes, that's not the end of the story, is it?
I don't think that I've posited that's my position, council or chair member, but I'm happily, more than happy to re-articulate it, but I do not believe that to be the position I posited. No, ma'am.
That you said that the ordinance says you have to have these things and you don't even have those 4 things, you have 6 things. I'm saying even if you had 8 things that said this address, does the zoning administrator not have the right and the requirement, the responsibility to look further, that those things do not, that is not the end of the story?
Yes,
Right?
I would agree with
Okay.
that statement.
You also said that the only reason we're here today is the renewal affidavit. The one, I guess you're talking about the one in which Ms. Daniel gave her address as 2659 Sporting Hill Bridge Road. That was dated the 28th of February.
That is the reason for the appeal.
But, well, that's not the only reason we're here today though, right? Because there have been how many calls to Hub Nashville saying that this was not your client's primary residence?
In the last 365-day period, which is applicable to the instant matter, there was one.
And wasn't that investigated by codes and determined there was no reason to believe that it was not your client's
That's
primary
correct.
residence? Okay.
They were unable to substantiate it, is what it says. So it's not the only reason, right? Because it's 2023, someone called and complained, 2024, someone called and complained, right? And then Ms. Daniel herself reported her address at Sporting Hill Bridge and voted at Sporting Hill Bridge. So it's not the only reason, right? But you're right. You have 4 letters from people, or you have 3 letters from people saying that they have dinner, they have drinks, they have relationships with this couple. So, and then we have one, Kristen Walker, an email saying that the home is rented out for 2 years, full-time, that it is not Ms. Daniel's primary residence.
I was not presented that document in the appeal packet.
Can I speak to that? Would that be okay?
Sure.
Kristen Walker was operating an illegal Airbnb, and you guys, after finding out 3 separate times, no longer allow her to Airbnb. I also have a police report on file you guys can pull where she threatened to kill me and my dog. She's very much a disgruntled neighbor who no longer can rent, and I think she's angry that I do. So if that clears that letter up.
That's probably the most dramatic testimony we've ever had here.
It was quite dramatic.
Well, the letters from the neighbors, I think, are certainly, the letters from the neighbors that claim that they have regular contact with you and dinner with you and dogs playing in yards with you, it certainly does speak to the claim, but there's a lot of other, there's a lot in this packet that tends towards Williamson County. Sean, go ahead.
Thank you. So just to clarify, your position is that your client's primary residence is the Cato Road and that her husband's primary residence is the Sporting Hill Drive. So 2 separate houses situation.
That's correct.
Okay.
Councilmember Parker.
So, congratulations on recently having a child. Are there crib rooms in both houses or only in one of them?
You want me to answer? They're in both. My husband owns a spinal implant company, so he has to be in surgeries at all the different hospitals downtown. So what works best for our family is that during the week when he has surgeries, that we are at Cato Road together with our child. And then on the weekends, his mom is 78. She just recently beat breast cancer. She lives in Columbia, so that house is much closer to her. We're over an hour and a half away being downtown. So on the weekends, we go to Thompson Station with her, and that's why we decided to rent out the home to make extra income while we're not there.
Great. And according to the voter registration details, you registered to vote in Williamson County on September 12th of 2024.
Correct. My son was born 6 weeks early. I had a complication during pregnancy. We spent 5 weeks in the NICU. He was 4 pounds, 5 ounces. It's my first child. I just did not feel comfortable letting someone else watch him or him not be with me.
Yeah.
So I registered to vote in Williamson County with my parents. And I have since re-registered in Davidson County.
Okay. And that was like you used the website to register in Williamson County? So it wasn't like you walked into the voting place and they said, oh, we're switching you over because you're voting in this
No,
precinct?
I had planned that. I did not feel comfortable by myself downtown. So I went to Williamson County to vote because I knew the baby would be with me.
Okay.
And Councilman Parker, just to be clear, no way trying to mislead you on that. I just misunderstood the comment, how that specific change went about for changing to Williamson County. So I just want to I understand your point. I just want to clarify that.
Within a county where you're already registered, you can generally update your address just by walking in, but I don't think you can do it in a new county.
I think I've done that in East Nashville, and that was my understanding. So,
Okay.
Just to clarify.
Thanks. That's all.
It was only ever meant to be one time, not for the foreseeable future.
Okay.
Did you cancel your voter registration in Williamson County?
Yes, and it is now back to Davidson County. I think about 2 months ago, it was switched back to Davidson County.
Okay.
So I don't know if that cancels Williamson automatically, but I am legally registered in Davidson County.
Okay, you did that. Do you know when?
We tried to look up the date. I can't find the date on it, but I think it was roughly 2 months ago.
It was prior to filing this appeal
Yes.
and prior to initiating any sort of administrative action.
Okay. And, okay, that's all I have for y'all. Thank you.
So I have another question. So I'm looking at your driver's license, Ms. Daniel, and it says that it shows Cato Road as the address, shows an issue date of 1/8/2024, and then, of course, we have the somewhat controversial affidavit that was submitted that Mr. Klein says was incorrectly completed due to a scrivener's error, but that was submitted on 2/28/2025. Can you help us understand how you got a new driver's license showing Cato Road in a full year and change before submitting the affidavit, and how that mistake came about regarding the address?
Yes, the driver's license was to change my name legally after getting married. It wasn't to change my address. And then the affidavit, I didn't realize you have a 30-day grace period. So I was rushing to fill out an affidavit. I forgot I had someone coming to my home to stamp the affidavit. And I was physically at the Thompson Station address because the Airbnb was being rented. So that's what I wrote down. I've never tried to hide that we, own that property as well. And in fact, it was the very next morning when I saw that piece of paper on the kitchen counter that I realized I had written down the wrong address. And I immediately sent an email saying, hey, this is a mistake. This is not, I did intend to write that as the emergency contact, but I should have put 4329 Cato Road. So it was dumb, and it was a mistake. It was.
The file is quite sizable, so forgive me if I've overlooked it. Do we have a copy of that email that you sent saying that? Okay.
I think it was with David Brabant.
Where might I find that?
Just 1 second, Councilman Vaughn. I've got it in a footnote reference. I just need to find my footnote.
Thank you.
That should be, I believe that is going to be on Exhibit 3 and Exhibit 4 of.
Exhibit 4?
Exhibit 3 and 4 of my petition.
Oh, God, my eyesight today.
So,
Okay.
Exhibit 3 is the email communication originally with Mr. Vrabit and Ms. Daniel. Exhibit 4 is the March 31st email thread between Ms. Alicia Bafar and Ms. Daniel. I'm again asking her if she was going to renew the permit again after the conversations with Mr. Vrabit, and that's when the revised and corrected affidavit was sent in, but then was ultimately rejected.
Okay, hold on just a second. Okay, received a renewal affidavit, that was acknowledged on. Okay, so that was sent on March 10th, the acknowledgement that the renewal affidavit from 2/28 was sent by Mr. Vrabit. And then I don't see, okay. On March 10th, there was a communication from Ms. Daniel. Okay. I am overlooking a statement from her saying that there was a mistake. You are able to use, once you have proved your affidavit. Yeah, I'm not seeing that. Am I overlooking something?
I didn't see it either.
Okay.
Do you want me to do it
Yeah,
on
I'm,
my phone?
It doesn't matter.
right, because I see some exchanges regarding, confirming that the affidavit's going to be sent or that it has been sent, an acknowledgement, and a query as to whether or not the permit would be renewed. I'm just not seeing anything saying that there was a mistake.
Even in your initial email with what's his name about having a conversation, you had even restated that this was a mistake. Can we get on the phone to clear it up?
What I did not include in this specific appeal, but was in, I don't know that it was in the appeal packet. It was in the public records request that was completed. But the email from me to David outlining, I know you can't consider it right now, so I can't forward it to you. I understand that. But that there was email correspondence. I had a subsequent call with David for about 30 minutes on that. And that is how we got to this point. And because everything I've presented in this petition was I've presented to David, and he said, this, you've got to go through the appeal process, like it says in the email thread from David in Exhibit 3, the email that, please remove all future bookings, which she did. She no longer rented. She made 30-plus days. She took all remedial actions required.
Okay.
And then that's when Ms. Daniel came to have a consultation with me. And based on that, when I was apprised of these facts, I reached out to David to try and resolve this prior to going through the appeal process. However, that's not a remedy that the zoning inspector is afforded pursuant to Metropolitan Code of Laws, so we are here.
Sure. So, Mr. Klein, it's your position that you are the one who discovered the mistake as to the address entered on the affidavit?
No, that was based on the email threads that I've been provided from Ms. Daniel, where I got this email from March 14th. And it says, the zoning administrator is determined to deny the permit renewal based on evidence that 4329 is not your primary residence, but is instead 2659.
Right.
So at that point, and then if you'll see, the next, where I guess, part of the confusion also comes in is that Ms. Bufar also sent that last year permit, grace period's going to end at 11:59 p.m. When Ms. Hammond got that, Ms. Cameron Daniel Hammond got that.
And I'm sorry, I've been calling you by the incorrect last name. I'm so sorry.
When she got, I told her, I said, maybe then this has been resolved. Go ahead and submit that revised affidavit, which is then that's included as Exhibit 5. And then it was at that point, once that revised affidavit was sent in and it was not accepted, after that point in time, that is when I spoke with Mr. Vrabit about these issues. And I imagine that I've got that date in the body of my petition.
Okay, I have Exhibit 5 is the corrected affidavit. Or should I say the second affidavit?
The Aaron affidavit would be Exhibit 2.
Yes, okay.
But we still haven't found
I still haven't found anything
any
highlighting a
emails
mistake.
where Ms. Daniel immediately reached out saying, oh gosh, that was a mistake.
Right,
The address should be X.
yeah. And if anybody else is seeing it, please point me to it because
Well-
my eyes are unreliable sometimes.
And
Mr.
that's
Klein,
not
is it
something-
actually in this packet? And if it is, can you direct us to it? Because I'm not finding it. It's not in Exhibit 3 or 4 like you suggested.
That is my client's testimony here as to how those events unfolded with her conversations with Mr. Bravid. Again, I understand we're not under oath, but I practice land use and zoning in this town entirely too much to lie to this board or to bring a client in front of this board who would do so. So I would just respectfully request that there be some presumption or benefit of the doubt with regard to these conversations and with regard to my specific conversation with Mr. Bravid.
And you know, I hear what you're saying. I think the problem for me is a few minutes ago, you were quite certain that it's in there, and now we're not finding it. And so that's where I'm having trouble. It's not that, and I'm certainly not calling you a liar.
No.
But there was certainty that there was a chain of events that sort of led to the submission of the corrected affidavit. And I was expecting to go in there and say, oh, okay, well, here it is, and we can move on to the next thing.
When I called Seth to hire him, I said, Seth, I've put down the wrong address, and I have already emailed saying it's wrong. And they said that there's nothing that can be done about that. I then hired Seth. Seth emailed David saying in the email that my client has filled this out incorrectly. Can you and I get on a quick phone call to put this to bed now due to that small error? And that was the whole basis of that conversation with David. Otherwise, I guess to me, that has to be true because otherwise he would have never approached David in the first place about trying. And I'm sorry we don't have that email.
And this is just a comment. Seth's a very good attorney. I'm very surprised he didn't submit a supplemental affidavit sort of outlining those facts so that would be a part of the record today. That would have made that much easier.
Duly noted.
So can I step off of the email or lack of email? That personally, that's not really relevant to my consideration, but why do you and your husband, why is it important that you maintain this as your primary residence, but your husband wouldn't just also have Cato Road as his primary residence if he's living there most of the time?
I don't think we'd be opposed to him switching that over.
I just wanted to know if there was a particular reason that it was important for you to maintain separate primary residences.
You know, when I bought Cato Road, quite frankly, we thought we might knock down the house. I have put a lot of love into that property. We have completely remodeled it, added 1,500 square feet to it. My dream was to have a garden and have animals. I now have 200 donkeys. I have the garden. You know, my heart is in that property. I don't think I would be willing to not have that as my primary residency. My husband has owned Thompson Station for so long, that property has doubled in value. We're not going to sell that property. I would have to ask him if he'd be willing to change over to Cato as his primary.
And I'm not suggesting that he needs to or has to. I was just wondering, I'm intrigued by this idea of having two separate primary residences. But that's all.
I have one thing. So I can't seem to find any of the listings in the packet. Do those exist, or do we have a sense of when the property has been listed as for Airbnb in the past?
As far as the advertisement?
Yes.
No, I can
And I'm asking because the appellant stated that she spends the weeks in Nashville and weekends in Thompson Station. I'm just curious if that pans out with the history of the account.
I can access that for you.
That'd be great.
And then I had another question for codes while you're standing here. I know almost all of the time when we have these denial because it's not their primary residence, the inspector goes out and takes pictures. And did the inspector go by the property at all, or was it just based on the fact that her husband's, I mean, acknowledging she voted in Williamson County, and that's not a great fact pattern. But all of the rest of her documentation is on Cato Road. Her husband's admittedly is Thompson Station, but it doesn't sound like she's trying to deny that. So did the inspector visit the property at all?
Yes, Metro, the lease program that we have for our Metro vehicles no longer allows us to go out of Davidson County.
Oh, no, sorry, I was asking about Cato
I
Road.
understand, but for insurance purposes, so we did not go to the Williamson County property. He did visit the Cato Road property on several occasions. It sets back off of the road quite a ways, and it sets back far enough that it was impossible to determine whether there was a car parked there or not.
Got it. That's all I wanted to know. So there was no, like, oh, we visited and there was never a car there, and it was just, you couldn't tell because of the setback. Okay, great, thank you.
But Mac, they did determine, I'm just looking at, this led us to investigate further. The appellant's Facebook page revealed that she and Mr. Hammond were married in 2023, and her Facebook page states that she lives in Thompson Station from 2023? Or do we wouldn't know when that was posted, I guess.
I don't love the consideration of like social media as a like documentation, because like I haven't updated my Facebook or my LinkedIn. I don't love when we have that in the packet, because I don't think it's reliable and it's not like a legal document. And I just find it a little bit like she does stay in Thompson Station on the weekends, but her saying I live in Thompson Station.
It's just an element.
Yeah,
of
no,
the
I was just saying
that
for the
investigators
purposes
put in the
of,
report.
yeah, I wish we would not get those, because I think it's oftentimes like it's a little intrusive and confusing to the fact.
Publicly available information, so I think it's totally relevant of them to put it in the packet. We don't have to consider it if we don't want to, but I think it's part of their investigation.
Are we approaching being ready to close the public hearing?
I think we really are. Does anyone else have any questions for the appellant, for Metro? Okay, thank you both so much. You can step back.
Thank you all for your time.
I
Oh,
will.
I'm sorry.
Oh.
I will check on the advertisements.
But now here's a question. If you're going to come back to Ramon with the ad and the weekends being used, you're free to go, or free to step back. Do we need to reopen the hearing to hear that information?
No, I
Yeah.
think that you can question me as part of your discussion. Is that not correct, Ann?
You can.
Okay. All right. So we're good. So we can discuss.
Okay.
I think he just provided the information. I think there was some crosstalk, but I think he just said that there were no listings after the.
Did you say that? I'm sorry, I missed that.
Maybe he didn't. That's what I heard, but.
I'm checking on that.
Oh, he's checking. Okay, sorry. Pending that information, I think she did provide at the time, or at least looking at what Metro was considering, the documentation that they were considering when they denied her re-upping her permit. I understand that her husband, clearly all of his documentation is at the Thompson Station address. Almost all of her documentation is at the Cato Road address. And the one aspect that, again, I think is not a great fact for the appellant, but she's not denying it or attempting to lie to us about it, is that she did vote in Williamson County. I think she explained why that happened. I'm convinced based on the signed letters from neighbors. She's got 2 donkeys at this property. I don't know why you would have 2 donkeys at a property that isn't your primary residence. It sounds like they spend the week in Nashville and the weekends in Thompson Station. I think I'm convinced that she lives there, even looking at the documentation that Codes was considering at the time, because I do believe that we have the ability to consider that rebuttable presumption that spouses have the same primary residence. But all of the documentation that Codes looked at, with the exception of her putting the Thompson Station address on the affidavit and her voting in Williamson County once, all of the other documentation that Codes provided us had her at Cato Road.
This isn't really helping us, right? We're not getting weekend dates versus. Sorry, this isn't really answering the question, right?
Actually, I'm going to jump in. Actually, I was looking at your rules again. I think I confused them with BZA. You just do need a motion to reopen the hearing.
Okay.
From MAC. So
I make a motion to reopen the hearing so we can discuss this calendar issue.
Second.
Can I see a show of hands? Meeting is reopened. You don't get to.
Yeah, unfortunately, Airbnb does not provide specific dates.
Yeah.
VRBO is much more specific, but that is the tracking that host is able to provide for us.
You know what might be helpful going forward is when they're doing kind of their investigation, if they take some screenshots of what the calendars look like, because if we just go off of the host compliance, we get this. But if we could see, once people take their ads down, we don't get any information. But when they're documenting these materials, it'd be nice if we got some screenshots of what the calendars look like, so that when we hear oh, well, we're there during the week. Well, if you're renting it 3 weeks out of the month, starting on Tuesday, then that kind of doesn't support the claim. So could we maybe speak to the folks that are doing the investigations about getting screenshots of what the calendars actually look like what the availability is going forward?
Well, yes, we can do that. However, the calendar itself, changes can occur to the calendar.
Mm-hmm.
And we would not know it. That's why we go strictly off of the reviews, because the Airbnb and the VRBO rules specifically state that you have to book through them, stay there, and pay through them, and then you have a certain allotted amount of time in which you can leave your review. Right. So that means that it's a stay that had to have occurred. Now, we would be happy to comply with trying to get screenshots of the calendar. It's just the reliability of that is not as great.
But do you know what I mean?
I understand.
So that is it available to be rented Monday through Friday?
You're looking for more
I mean,
specific
it was in
data.
the last packet, so it would be nice if we could be consistent with that. It was in Mr. Miller's packet, so it would be, and it would have been helpful in this particular case where, again, it may not have been a silver bullet, but at least it would have given us another data point to make a decision against.
I think we're seeing though 2, 3, 4 documented stays a month that is consistent with renting it on the weekends.
Could we also scroll to the bottom of the page? I just want to see the rest of the page. I don't like looking at anything that could be considered evidence and not seeing the complete screenshot. It looks like we're about a little over halfway down the page right now.
And if we're able, sorry, Ann, this may be a question for you. If we're able to consider this information right now, which is new information to us, if she provided the email that she's talking about, could we consider that as well, since there were a lot of questions about the email between her and...
Well, you can consider the information that's presented to you in the public hearing. I mean, you could defer the case if you felt there was additional information that you wanted to...
Well,
see
we're
the
receiving
screenshots?
additional information right now from Codes, so, and that was not provided previous, and it seemed like her attorney was saying that he couldn't, he seemed to feel that he was bound by what he provided in the packet. But if we're able to consider information that was not in the packet from codes, could we just ask her to show us the email? Because, since that was a point of contention. I think to be consistent, if we're looking at information from codes, yeah.
Right.
Can they email it to you and then show it to us? I guess is the question.
I was only going to add one little point of order that you all give Mr. Klein the ability to rebut what Mr. McBroom said.
I'm sorry?
If you're re-upping
Yeah.
the public hearing, just one guy's opinion, I think he ought to have the opportunity to.
We're
Okay,
reopening
just
the
did.
public hearing.
No problem, thank
And
you.
I have no doubt Mr. Klein will share anything that's on his mind.
Also, there appears to be an active link for listing screenshot history. Is that something we can open? Do you know?
Looks like it was from March, not active, but
I want to know that for sure.
yeah.
The list was removed on the 29th of March, so those are two screenshots from before it was removed, I presume.
Right, so I mean, basically you need to have it as an exhibit submitted as evidence. In the rules, you have under submittals, which is under 6D, there's language to the effect that documentation the applicant or opponents wish to provide to the board after the deadline can be presented to board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. So in your rules, it contemplates, having the 8 copies or deferral. If there's a reason that you want to, suspend your rules for any reason, that's another option, or defer the case. So it depends what the board would like to do.
I'd be perfectly happy to suspend the rules.
Yes.
And look at Ms. Daniels' phone
Yeah.
rather than
I'm gonna make a motion to suspend the rules to allow for the consideration of email evidence exchanged between the appellant and/or her representative and codes.
And to require that it be submitted. into the
Yes,
record.
and to require that it be submitted to the codes department after this hearing as an exhibit for the record.
Cool.
Well,
So
I just
do
made a
this-
motion to suspend the rules, so.
If we agree to it and then Mr. Klein does not want to submit it, is that a problem?
Sorry, I just didn't hear. I was looking for the
Okay.
email. I thought y'all were talking amongst yourselves.
I just made a motion to suspend the rules to allow y'all to show the email or emails.
Second.
Okay, great.
Can we see a show of hands on suspending the rules? Okay. Unanimous among voting members?
Showing your email.
Yeah. Yep. Is that okay? That's fine. No one look at anything else. Do you realize you're broadcasting someone's email? There you go.
Oh, yeah.
Oh, yeah, let's take my glasses off for that.
I guess like reviewing that, the question that's before us is like whether the person lives there, not whether they filled out a form incorrectly. Like if that's what led our folks to investigate the situation, was a form being submitted incorrectly, then okay, that's what led to our folks investigating the situation, but we're not really discussing the specifics of a form.
think the reason I'm concerned about the form is it's a legal declaration. And I wanted to, yes. I mean, it's a sworn statement, so that's why I'm always interested in what those things say. Okay.
Yeah, well, I guess she's swearing to that I'm over the age of 18, that I'm the designated representative, that I wish to continue the permitted operation, that the floor plan hasn't changed, that I possess full insurance, and that I have not violated the requirements for operation of a permitted STRP. I think the affiant information is not what she's swearing to, for whatever that is worth.
That's news to me.
Well, I mean, it's not included in the list of things that she swears to, but I'm not a lawyer, but also I don't really, it doesn't sway me one way or another that she put the wrong address or says that
As
she
a
puts the
lawyer,
wrong
I have a
address.
different read on that, but I respect
Well,
your
have you
opinion.
looked at the form?
I have.
Okay,
I think
she signed it before you get to the affiant information, so anyway.
So
Interesting.
to be fair, the public hearing is open, and I think it would be unfair not to let Mr. Klein and/or Ms. Daniels speak if they chose. But I do think what's interesting about the email was, it was, the minute I saw it on the desk or the counter the next day, I was like, oh no, that's terrible. And I immediately, but it wasn't. That's dated 3/17.
Yeah, I don't know that she said the
And
next
original
day, but
affidavit
yeah.
was
But yeah,
2/28.
it was 2 weeks after
Yeah.
the, no, it was March 3rd.
And the acknowledgement was on March
Was-
10th.
Yeah.
The original
Right.
affidavit was 2/28, and the follow-up email was 3/17.
March 3rd is the original affidavit. The notary's commission,
Is the
the notary's commission expires on 2/28, but look at this, the 3rd day of March.
No, I have a signature under further fine, say it's not. The signature and then the date is 2/28.
Oh, no, sorry, it was notarized on March 3rd, so it wasn't submitted on 2/28.
Okay.
She filled it out, put the date, went to the notary a few days later and got it notarized. So it wasn't, that's all I'm saying. Yeah, I completely agree that it was a couple weeks. Also, again, I don't find this particularly relevant or convincing, but I knew that people were asking about it, so.
Okay.
Okay. I'm about to close the public hearing unless you guys have anything to add. Please go right ahead.
Just to be brief, thank you for the opportunity to substantiate our position and claim. I did forward the email to Mr. McBroom and Mr. Hargis that I sent to Mr. Vrabit, including all the information that was in the packet today. So with that, again, I appreciate it, and ultimately, it's dates are they're it's a timeline. There's probably some differentiation in between there, some room. Point being, based on the evidence that I believe that we have presented, I think that we have reasonably overcome the reasonable presumption with regard to the spousal residency and to prove, based on the documentation that is required pursuant to the MCL, that this is Ms. Hammond's primary place of residence. Thank you.
Thank you.
Thank you. Okay. So we're going to close the public hearing and we can resume discussions. Mike,
So,
Sean,
I'm going to have a really hard time thinking that the zoning administrator erred here. And in a lot of these cases where the residency is the question, we have a lot of changed documents kind of in the short window leading up to here. We have testimony that, essentially was living in Williamson County, voted in Williamson County in the fall. And I think if they are now staying at the Cato Road as their primary residence, I think maybe just it's more appropriate to just give it a little time for the dust to settle and then reapply. Just seeing
The addresses on the, documents didn't change.
Are we doing like where we recognize one person?
Sorry,
Or are we
I'm
just
sorry.
doing like a free-for-all thing?
Continue, Sean.
It's wrong.
So yeah, so all these documents have changed in recent months ahead of this application, some of them after the notice of revocation. So I think this is a case where just a little more time to kind of establish that residency again and would be a better path than finding that the zoning administrator erred here.
Before Nicole jumps in, can I just confirm with you what documents did change? I mean, voter registration, yes, but it seems to me that her driver's license was from 2024 with Cato Road. What other documents changed? I'm not saying they didn't, I'm just saying, remind me.
Well, then it's the voting registration.
Vote, okay. But is that the only one that has changed?
We could either ask staff or we could.
No,
look
I'm
through
gonna,
the document.
let's not reopen the public hearing.
No.
Be here until midnight.
Is that in our rules that we have to open the public hearing to hear from staff?
I believe so.
I'm sorry, could you repeat the question?
Our rules require us to open the public hearing to hear from staff.
I know what I was thinking.
That's weird.
But, I mean, I have different boards and commissions with all different rules, and I was just looking here, and it did seem to require it here. Sorry.
We have been violating that rule. Yeah, I don't think there are, Sean, other documents that changed. I mean, voter registration is a pretty big one and pretty telling. But I actually don't think, I think her driver's license was, right, from 2024.
The beginning.
Yep. And then she had some tax returns or an Amex bill or whatever that didn't seem to be new. So, I don't know. Actually, that might be new.
Can I be recognized?
You may be recognized.
Thank you so much. That was exactly my point. Thank you. All I'm saying is what I saw was one document that changed and a whole lot of documents that did not change. So if we're looking at the totality of the evidence, I saw one document that changed. An explanation for that, you can decide individually whether you find that compelling. I do personally, but then a bunch of documents that did not change.
But you will agree that the circumstances changed. I mean, she married in 2023 and her husband's primary residence is the one that her voter registration changed to. So, I mean, it's not like it's without some merit to discuss it.
Exactly, and I think we have discussed it a lot. I think we have, but yes, 100% circumstances being what they are. I still think given the weight of the amount of documents, even just taking out what they provided in the filing from Mr. Klein, just looking at what Codes was considering, I'm seeing everything for her except for that voter registration being at Cato Road and everything for her husband being at the Thompson Station address. And so to me, she has met the burden to suggest that she did live there as of the time that she applied, as of the time that Codes was. And I don't know what that means in terms of, did they err, did they not err? They made a determination. We might make a different determination based on the same evidence. So I don't really know. Anyway, I think she lives there. I think she has lived there. And I think she was living there when she applied for the permit. And I don't know.
Mr. Bond, anything to add?
Yeah, I've got several thoughts actually ping-ponging around my brain. I don't know if I could even.
Would you like to think while I harass this end of this?
Please do.
I'll go.
Go, Mike.
Yes, I also am inclined to believe that the appellant did and does live there. However, I have severe reservations, considering the standards that we've used in the past and what this would possibly set, about married people not living in the same household and what the implications of that could be to the future. And so it doesn't seem like that, it also doesn't seem like that staff erred, because I think that given the evidence that they saw, I think that they made a reasonable decision. So I don't really know where to go, but that's what I'm feeling about it.
And I think that's a lot of the trouble that I'm having as well, is we're looking at, we're pinpointing particular points in time, and if we're determining whether the zoning administrator erred in making its determination, we're looking specifically at what they knew and saw on the date that they declined to renew the application or renew the permit and institute a revocation. And if I'm not mistaken, at that time, there had been no suggestion yet that there was a wrong address submitted, and then there were other documents that suggested that the residence might lie somewhere other than the Cato Road address. So that's where I'm stuck.
Yeah, and I think, I completely understand the concern about setting a precedent about married couples. I think the law tells us, we've heard the law says it's a rebuttable presumption. Even Mr. Hargis said that, it's a rebuttable presumption. So if it's a presumption, but it's rebuttable, we have to allow appellants to rebut that presumption. So I'm not concerned about setting a precedent, because I will also say I think this discussion has been very deliberate and well-considered, and we are going through the evidence with a fine-tooth comb. So I'm not concerned about that, meaning that everyone can just come in and say, well, I live in a different place from my spouse, why don't you just believe me? I'm looking at the evidence here in this case. I feel that she has met a burden to rebut the presumption that she lives in, that her primary residence is the same address as her spouse. But that's, again, just me.
But we know more now than the zoning administrator did at the time that the decision was made. So, and I think that's where the code limits us in our consideration.
Well, and so I would love to know, does the code limit us? Because then why do we have these here? Like, why do we allow them to submit supplemental documentation if we can't actually consider it?
Listen, the law doesn't always get it right. It's not always written.
That's what I'm asking. And I will say everything that I have said, I've been very deliberate. I've said, looking at what codes was considering.
Right.
Take out of it whatever she provided, even if we are bound to just what codes was considering. I think that the weight of the evidence is in favor of her having Cato Road as her primary residence. But I would like clarification on why would we have them provide information if we can't consider it?
Also, I think that's not really the issue, though. It's not whether, it's whether the zoning administrator erred or not.
Well,
Right?
I think that's part of the question.
I think we decide that first, but then we can decide on whether or not there's relief. I think what's difficult about this case and these cases is that the permit has been denied. But that's actually kind of a good thing too. There's no 1-year waiting period.
There is a waiting period now with the new ordinance. After you have a permit denied, isn't it like a 6-month waiting period to even reapply? Because that was something I actually was opposed to when the council was considering the new ordinance, because we've told people in the past, just reapply and get your documents in order. But now I believe, unless I'm mistaken, that there is, once your permit application is denied, you actually have to wait.
You're not governed by the previous ordinance that governed you.
It would be a new application.
They're starting from scratch.
It would have to be a new application.
Yeah, I think that's correct.
So she would have a 6-month waiting period.
6 months or 1 year, I think. But if Ann could.
Oh, we should know what this new ordinance is, which I don't.
Good question. Give me
It's an excellent question.
That's why I struggle with this, because in the past, before
Yeah.
this latest ordinance, which was sponsored by Councilmember Allen, it's not the one that gives us more factors to consider. There was another one after that.
Because in the past, we've said,
We've
when
said,
your
just,
circumstances change.
yeah, get your
circumstances
documents
will
in
change.
order
Right.
and then go apply.
Yeah, yeah.
But if that's not the case anymore, which I don't think it is, then it's sort of, this again was why I was like, I don't agree with that. But we're not a legislative body, and the legislative body made a decision.
Punctuated with the papers falling to the ground.
Yes.
Well-
Even though Mr. Klein has attempted to promote me and Mr. Bond to council members, we are not.
While Ann digs through that ordinance, were you done? Sorry, Mike, I feel like we cut you off. Phil, you've been quiet.
Ruminating. I do think about the implications, but about, changing or potentially what this does for future cases. But I tend to agree with Nicole again, which is strange. For as many times as I've shown up to these meetings. I'm still chewing a lot on this.
Ruminate,
Yeah.
ruminate. You've got time. We booked the room all night.
I do
It
not
would
want
be
to be here all night.
so helpful
not
if
be
we
here.
actually had a case on point on this issue. It would be incredibly helpful, but
Had many cases, I feel like, on this.
no,
issue.
not this kind of issue, but like literally for this purpose, it would be helpful for me, because we get like, well, there's case law, but also the state law, and also Metro Code, and so I'm just talking to talk, I guess now, sorry.
I think I really want to wait to hear
Yeah.
from legal.
Seems kind of unsportsmanlike if their permit is denied, to
I
then make them
agree.
wait 6 months to even
I agree.
discuss it.
I agree.
But
Is that a Berkeley Allen joint?
And I don't know, that is Councilmember Allen, but the entire council voted in favor, I believe. But I don't know, and I don't know that that's something that we can lessen the wait period on. I don't think that it is.
I see the board has discretion under the notes or in sort of the top portion where we typically see that information.
Yeah, but that's wrong
But what kind of
sometimes.
It is
discretion,
sometimes wrong.
Yeah,
right, I'm not
That's-
sure what discretion do we have? Like, if indeed Ms. Daniels' permit being denied puts her at ground zero. And if indeed.
worse than ground zero.
Yeah, negative, -6. Okay.
Unfortunately, I don't know if that's really relevant,
I
the
know.
punishment, right? I mean,
Well,
I know that's
but
part of like,
aren't we-
of
yeah.
shortening.
If we have authority to
waiting
reduce a
period, if we have
wage.
that possibility, but really, like, it's,
I know, the question is still, is it her primary residence or is it not? But you can see, like, in the past, what Nicole and I were saying is that we've had this kind of grace note of saying, hey, look, we think you live in Alabama. When you move here, apply.
Yeah.
You know, and we think you live in Thompson Station. You know, there's no reason that your husband can't say, oh, you know what, you're right, that's my weekend house, I'm gonna make this my permanent. Revisit it. If indeed this new ordinance is going to put that in jeopardy, then I think we just want to know that.
Okay, so she applied for her first owner-occupied permit. Application was submitted in March 2023 and issued in that same month. And so Bill 2020-187 was in effect, and it does provide that once an STRP permit has been revoked, no new permit shall be issued to the applicant for the same property for a period of 1 year.
But is revoked and denied the same thing? Her renewal was denied. Her permit wasn't revoked.
I think they're considering
This is a
it the
revocation
same
action, if I'm
here,
not
because
mistaken.
effectively she was trying to renew, but
Yeah.
rather than renewing it, they denied it, which is
So they are
effectively
one
a
and the same.
revocation, like,
Yeah.
Okay.
Okay,
yeah,
that's helpful.
that's how I understand it. But
And I'm sorry,
but
the
you
waiting-
could find the zoning administrator did not err and still change that 1 year wait period, right?
Okay.
Okay, that's helpful. Can I just throw out a motion and see?
Sure.
But before you do, can I just, do anyone ruminating want to weigh in before
They
we
can,
have a
and
motion?
they can talk after the motion as well.
Thanks for the call out there. Thank you. That's all. I have my decision.
Everybody's good? Because there's a motion coming your way.
Okay, I'm going to move that we find that the zoning administrator did not err, given the documentation that codes considered at the time. However, given the weight of the additional evidence, I would move that we reduce the waiting period for reapplication to 0 days.
Second.
To 0 days.
Yes,
Yep.
she could apply tomorrow.
I think that's reasonable.
And provide the documentation at that time. Codes can look at it. If they still don't agree, they can deny it and file another appeal, whatever.
I agree with everything you just said.
Can I see a show of hands?
Okay.
Looky there.
Woo!
Right.
That was a tough one.
That was not easy. All right, so that's done. That's it. That's our last case.
We got more stuff.
We do.
have admin stuff now.
So, very good. You're all set. You're going to consult with staff, and Alicia, you got it was unanimous, and that closes the public part of the hearing. I don't know if we need to leave it open for our housekeeping matters. Do we leave that open to the public?
I mean, it's all public.
It's fascinating if you
It's not
want to
closed.
stick around for it. So, okay, thanks, everybody.
Thank you. Thank you.
That was a lot to get to. To get to the starting block. No, for sure.
Yeah.
So,
I would like to ask for this additional matters that we're talking about, if I could get a rough time estimate, I have to coordinate kids and stuff.
you bet.
Just a rough idea.
Well, we have to do ethics training?
Yeah, it's about like 15, 18 minutes, kind of depending on how many questions there are. The rest of it is up to you, how long you spend on the other matters, those are up to you. Just the board election, the vote on the rule change.
What if we did
so-
the election and rules first, in case any of us have to leave?
Yeah.
Yeah,
Yeah.
you can.
Can I vote
so-
on rules or no?
So would people,
You're a
I'm so,
non-voting member, yeah.
so, is it possible that people are leaving before the rule change vote or the ethics training?
I have to be somewhere at 4:30.
Fine with me. I
can't
find
vote
you to be
anyway.
incredibly ethical, so.
So you can go ahead and just like have a motion to like revise the agenda, to change the order on the agenda. And just-
Okay, so I don't have a copy of the agenda, or do I? Wait, hold on.
Because right now it says board election, ethics, and then the vote. And because there are two issues, one is just like a cleanup of language, and the other is a little more substantive regarding quorum. I think it's an issue that had been like pushed from a previous meeting, so.
Okay, so Alicia, we don't need that up just yet because we are going to change the order. So what do we want to start with? Do we want to start with voting on the rule changes on a quorum? We have a rule change on some language. We have board elections, and I think we'll do ethics last.
I think we should do elections, rules, then ethics.
Okay, so I'm going to make a motion to alter the agenda, to reorder it. We're going to start with board elections, go to rules, then do ethics training. Do I hear a second?
Second.
Can I see a show of hands? We have unanimously agreed to move things around. Okay. Oh, this is fun. So, I feel like we just did this. Board elections.
Yeah, we were late last time.
We were very late
Yes,
last
yes, we
time. I'll start with the easy one, which is I would love to nominate Terrence Bond to remain as vice chair if he would be willing.
I will accept the nomination.
Very good. Want to have any discussion?
And you can also take additional nominations.
Or discussion and or additional nominations?
Does anyone else want to be vice chair? That's a relevant fact. Okay, great, then I'm ready to vote.
All right, let's see a show of hands.
By acclamation, look at that.
I'm going to nominate Chair Julie Ryan Caputo to remain as chair, if you want to.
I'll second.
I would be delighted to stick around. I'm also happy to pass the gavel if someone is itching.
If no one's itching to be vice chair, I doubt anyone's itching to be chair. So.
We're an itch-free society.
Okay, I'll see a show of hands. Phew. Well, that was easy enough.
Look at that.
Okay, shall we move on to rules? Do we need to document that, Alicia? Everything was unanimous. Terrence remains. I will soldier on. You got it? Okay, cool. Okay, now the rule changes on the quorum issue. I guess this is because the council no longer will let Sean vote. Is that right? Is that why we're in this position?
It's the charter, it's not the
Yeah.
council's fault.
That is correct. And so it
Didn't
creates
some
some
council
funny
members weigh
situations for your board. No, because most boards and commissions, I mean, some do, but some don't. And so it just means, so I believe prior, you did change the language regarding, let's see, case decisions, right? So now the appeal can be granted or denied if it receives a majority vote of those voting members present. I believe you already voted on it and approved that, right? Because it created some illogical situations if, right, you say you had 4 people present, including Councilmember Parker, and then you had a 2-1 decision, but then 2 would not be a majority of those present, right? So we're just trying to avoid that situation.
Okay.
Yeah. So that rule change already happened, and now the other rule, I guess you deferred thinking about the other issue about how you would decide whether or not you had a quorum present.
Okay.
And so one change that was contemplated was saying that the presence of 4 voting members would constitute a quorum. So, you know, you guys have problems with quorum sometimes, so that's something that I think you should think seriously about, whether or not you want to have the council member to count towards quorum. Like, you know, I think the voting issue you already fixed, so, you know, it's really up to you how you want to handle that.
I think Sean should count.
He should count for something,
Yeah.
so. Yeah, I think that makes sense to me.
I think that's fine. I'm good with that. What do you guys think?
Yeah, and if an appellant is like, no, I want 4 voting members there, then they can defer.
Right.
Like if they're,
What's the purpose of quorum? So we can have a vote, right? I mean, no offense, Sean, but I think if you
I was going to say, I actually
vote,
think it
then I don't
makes,
think that would contribute to quorum.
I think that the change that's proposed actually does make sense because
Well, just to
I think it
clarify,
doesn't
they're,
matter.
no, they're actually, if you do nothing, then you will remain considered
That's what-
part, then you will
that's what I'm
remain
saying.
counted for quorum.
I think the change actually might be sensible because of what the voting requirement is and the quorum.
no,
That's
the
thing, they
voting
already fixed it.
requirement is just a majority of voting members present and voting.
Oh,
We don't
already-
have
that's not even
a,
full,
yeah.
okay. Yeah.
So that's why I'm saying,
He can only help us create a quorum. He can't defeat one.
yes.
Right.
Oh,
So yeah, I think that's
oh, yeah, then that's fine.
yeah.
I think
I was
it's
thinking
fine to
differently about
stay
Yeah.
as is.
Yeah, so you can decide, yeah, exactly, to do nothing, like you don't have to.
So we require, what it reads today is it requires 4 members and I can be the 4th.
Correct. You
Well,
are
okay,
still
that's what
counted towards
let's
quorum
leave that,
today.
yes.
Okay, well then I'll make a motion.
Do we need to move on that?
I think if you're not changing your rules, you don't have to do anything.
Oh,
Then
perfect.
let's, oh my God,
Moving
we're
on.
so good at not doing anything.
Moving
Can
on.
Max speak for a moment? He just wanted to address you.
This is something that could be reconsidered if you realize that Ms. Kimberling was due to be replaced and the replacement was chosen and then backed out. And then the new ordinance is going to allow us to have another member. And so once we have the full membership of the board, this might be something you'd want to reconsider at that point. But I think it makes sense now to be sure that we have quorum because for instance, next month, we have 8 cases. It's very important that we have quorum because if we don't, then July might hold 16 cases. So consider.
Please come to the meeting.
Please come.
Yeah.
Okay. I think part of the reason too about the voting rules has been when people recuse themselves. And I don't think we've had like one or two cases in 5 years where anybody recused themselves, right?
Yeah.
So, yeah, I think we're good.
Okay,
Okay,
so moving on.
ethics training.
Okay.
The moment
I'll
we've
give you
all
a
been
moment.
waiting for.
I'm happy to start it. If you want to take a quick break, you're welcome to.
Let's go.
You can just go. You want to
You
go?
guys okay?
Let's get on
Let's
through,
go.
yeah.
I have to leave in 5 minutes. I have to say that,
Is there
so I'm
makeup?
sorry about that.
Is there a makeup ethics training for mine?
But I have attended ethics training
Can
in
you talk
previous
really
years,
fast?
if that's acceptable.
Alicia reminded us, I'm so sorry. There's a cleanup rule change also, which I.
So much for ethics training.
Oh, that's
Do
about
you
like
wanna put
appellant
that one?
language.
Up there? Yeah, it was just like a cleanup, just fixing the language. It wasn't, from what I recall, it wasn't really substantive. It was just
I move that we approve.
I think
I looked at it. I don't
Second,
need it
actually.
projected in front of me here. I read it.
Is it like a typo?
Oh, I remember reading about it, yeah.
let's look at it, because I want you to make an informed decision.
Well, to be clear, I did read it when we got the packet, so.
Oh my God. That was crazy, yeah. I'm like, wow, okay. Ooh.
It is
That was a lot.
a change to Rule of Procedure number 6, to provide information to the board in a timely manner, any documentation that appellants, and that's a change of a word, documentation that supporters or opponents want the member, adding an S, members of the board to read, and then documentation the applicant, and that's changing a word.
Is it in the packet? I thought it was a separate document.
So
It was a separate email.
We're changing singular to plural?
But this was a
Yes,
couple
and-
years back, right?
God.
No, this is for May. It changes 3 words.
And it's really just corrections.
It's singular or plural. Okay. Okay, gotcha. Move to adopt as amended.
Second. Can I see a show of hands to move to adopt as amended? Unanimous.
All right.
All right, oh, now
Stop making me wait for the ethics training.
I'm really impressed that you're that excited about this.
We're excited to go home, I believe.
I'm sorry.
That you feel.
Yeah, I know. So we're required to do this every other year, so it's probably been a couple years since you've had your ethics training. Some of you have heard this probably ad nauseum. Some of you, this may be new to you, so I'll try to go through it pretty quickly. I'm Ann Mickelson. I am your client advice attorney from Metro Legal. I think I've worked with you for over 3 years now at this board. If you have questions, feel free to stop me as I go along. I might know the answer. I might have to research it and get back to you. A lot of the ethics scenarios are kind of fact dependent, so a lot of it will kind of depend on the specific situation. Okay. All right. Are you going to be able, do you want me to change it, or can you change the slide? Okay. All right. So these are the overall goals of the training. I'm not going to read through them all right now, just because we're going to go through them one by one. And I don't want to take up too much of your time. Okay, so goal number 1, understanding you cannot accept benefits related to your role on the commission. So this probably seems like pretty, common sense stuff. Still, though, I'm just going to go through and talk about the highlights of this. This is derived from the Metro Code, Section 2.222. That's the General Ethics Ordinance. And it applies to all Metro employees, including commissioners and board members. So there are a lot of prohibitions, including you shall not accept or solicit any benefit that might reasonably tend to influence you to act improperly in the discharge of your official duties. Shall not use Metro property, services, or funds for personal purposes. Use non-public Metro information for personal gain or for the gain of any family member or other employer. Use a Metro position improperly to secure unwarranted privileges or exemptions for yourself, relatives, or others. Accept other employment which may impair your independent judgment in the performance of your Metro duty. Accept any benefit which the employee should reasonably believe was intended to influence any action taken in the employee's official capacity, or give a reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they're unduly affected by the kinship, rank, position, or influence of any person. That's kind of like a catch-all, like, is it giving a bad impression, a bad taste, like things you would not want to see printed about you in the newspaper or online or anywhere. So there are a number of other prohibitions as well. If you want to go ahead and read Section 2.222 of the Metro Code, there's a much longer list. There are some limited exceptions to this rule, but I will say there's the big caveat, which is, for instance, you could take awards of trifling value, like if someone gives you like a plaque commemorating your service on a board, gifts and hospitality unrelated to Metro, you can still have birthday presents and go to the beach with your family. Under the rules, there is an exception for food, beverages, et cetera, like under $25, and also an exception for free or discounted admissions tickets. And this is all from a single source in the calendar year, both the 25 and the 100. The tickets up to $100 in value or more than that if it's for tickets for a fundraiser for a nonprofit. Again, always that kind of caveat. Does it look bad? Like, is it something that feels like someone is trying to sway you? If it feels like it has a bad taste to it, if you feel like it looks bad, I would even avoid these kind of de minimis situations. So that's just my overall take on that. All right, so there is a Metro Board of Ethical Conduct. Let's see, can we switch to the next slide? Thanks, Mac. So there's a Board of Ethical Conduct. It hears complaints. It renders advisory commissions. Thank you. No worries at all. You got through the first 4 slides, so that's pretty good. We'll give you a pass. All right, and so an elected official or member of the Board of Commission can ask for an advisory opinion if they'd like. Let's see, next slide. Complaints regarding elected officials or members of boards of commissions can be made to the Board of Ethical Conduct, in which case the Department of Law investigates, makes a report to the board decides whether or not to hold a hearing, and the parties can present the evidence. Regarding penalties, there could be a recommendation to counsel the person be censured, a recommendation for resignation. The matter could be referred to the DA if it seems criminal, or to the Department of Law if it's a civil matter. Okay, goal number 2. This is regarding understanding when you may be biased or have a conflict and should recuse yourself. So on the next slide. This is the one I get the most questions about. People are actually, not for this board so much, but there are other boards and commissions where people on the board actually are routinely kind of in the same kind of business sphere as people who appear before them. So it's more likely that they're going to know people appearing before them, either through just social circles or business. So overall, it's important to remember that you have a duty of independence. So you cannot act based on your self-interest or based on bias against or in favor of people who you know personally, or based on the interest of the director or contractors with whom your board interacts. So you can't be biased towards anyone within Metro or outside of Metro. So you have to be impartial and act based on the law and the evidence presented to you. Okay. So next slide. We have a couple different scenarios here. I have a potential conflict. Should I recuse? Yes. The easy one is you have a financial stake in the matter, right? Say you own an STR property and or your next door neighbor owns an STR property. Well, sorry, that's the next one. So yeah, financial interest, definitely recuse. Bias or prejudice for another party as an individual or as part of a group. So if it's like your neighbor, right, it would be very uncomfortable for you to come up here and refuse your neighbor, an STRP permit if they've been revoked or denied or something like that. That would be a very uncomfortable situation. If it's someone that you do business with, any kind of situation where you feel that your decision is going to be influenced by something other than the evidence that's before you. Okay, and if you cannot fairly or impartially weigh the evidence because you prejudge the fact issues, and what this really means is that if there's a situation where you could never come to another determination no matter what the evidence was. You've had some kind of inherent bias about a certain kind of situation or person. But of course, it's fine to review the evidence in your packets. That's what you're supposed to be doing. So you're always going to come to the meeting with some ideas in your head about where you think you might go. And of course, then you hear the rest of the evidence and make your determination. All right, next slide. So no, you don't have to recuse yourself so you're not going to gain or lose based on the decision, and if you really do believe you can be objective, and that your participation will not create an appearance of impropriety. If there is a connection that you feel that someone's a business associate, it's good to disclose that information beforehand, just so that it's always good to be transparent and disclose more rather than the other way. And you can disclose and say, this person is, we've met, we're in the same social circles, however, I believe I can, act impartially here. Okay. In general, you have a duty to vote, and you should do so if there are not grounds for recusal. Okay, next slide. All right, so if parties are attempting to lobby you regarding the kinds of issues that become before this board, that needs to be disclosed, and those parties need to be directed to staff, right? All evidence that you are using to make a decision needs to be public. So it can't be something that only you know. So make sure when people try to approach you about something here, send them to staff. It shall all be in the public record. And if it's not for some reason, explain and disclose. And of course, you wouldn't be accepting gifts from anyone appearing before this board. All right, next slide. So you need to remember to disclose knowledge you've received about an agenda item from outside the meeting. For example, if you do a site visit, if you drive by, this is maybe more applicable to some other boards, but sometimes I think that could happen here. If you have relevant knowledge, for instance, like your legal expertise, right? Like that leads you to look at certain documents in a certain way. You might have another kind of expertise that you bring to bear upon these kinds of XTRP situations. And that knowledge can also be attempts to lobby you outside the meeting, which again, you always need to disclose. And they shouldn't be lobbying you to begin with. All right, goal number 4. You want to remember to articulate the specific reasons and the basis for your decision. So if these cases ever go and get appealed and they go to circuit or chancery, you want to make sure that the record before the court is really clean and good, and they say, okay, I see why you made this decision, I see the factors you considered, I see why you determined that the zoning administrator erred or did not err, and it's very clear and that record is very clean, then they're more likely to uphold your decision. Understanding what you're reasoning. So you want to look at acceptable reasons or criteria and the relevant laws, right? Like those modification factors, which you've talked about today multiple times, the facts presented at the meeting, past experience with similar issues, if there's studies by experts, specific observations made by the public, right? If you have complaints you're taking into account, if you have members of the public who come and testify about their experiences, what they've witnessed. Now, some unacceptable reasons for making a determination would be, let's see, next slide. Just sympathy for the applicant or people who are opposed to the approval. Like they need the money. Now, some of this is a little bit baked into some of those modification factors, but you need to really go through those factors and make it really clear how you're thinking about it. And also, it can't just be opposition that's not based on the relevant laws. And I know sometimes you have people who come here and just say, I just don't like STRPs, right? Well, how that pertain to this particular case before you? And I think you guys are really good at sussing that out and figuring out what's pertinent to the case before you. So you do a great job with that. Okay. Yes. Yeah, one slide? Back a slide? Can you go back a slide? Just one slide or more than that? Yeah.
So I feel like even in the case we have today with
Yeah.
I don't think that's what we made the decision based on. And I think it was, for me, it was just like, okay, then it makes sense why stuff fell through the cracks.
Yeah. Right, and we've had other people who, somebody was deployed, right? Somebody had an assignment in Georgia for a few months, like, those all, I don't think it's, it's not the sole, it's not like, who give me my permit back, my mom got, like, yeah. And I like that house, that's beautiful.
Oh, yeah, that was a historic zoning case, that was not a historic case. So for instance, like there is a factor on those remedial factors, right, there's one, undue hardship, and that refers to whether the failure to grant relief would result in exceptional practical difficulties or undue hardship upon the appellant. However, any such hardship or difficulty should not be self-imposed, created by the actions of any person having any interest in the property. I would say that like global sympathy is not necessarily one of those factors we're looking at here, but hardship is a factor you can take into consideration, so.
We do get that, we're constantly being told that's $20,000 worth of this, or this is, do you know how many things I had to cancel?
I think we're good
Yeah.
about,
Yeah,
sorry.
yeah,
Self-induced,
yeah. So, yeah, you have those factors, you have that language there, and I think you'll do a good job of applying it. So, okay, let's see. Ordinance updates. So as you all know, and as I think you've already been sort of seeing put in practice, there were some short-term rental ordinance updates that came into effect back in November. Let's see. And these include, let's see, the language. You can modify the penalty, right, as you've done many times. This common issue that you have is whether or not the owner can occupies the property as their primary residence as proven by documents. And so the term was changed to primary residence, which is different from permanently reside in 1704-060. So it's not necessarily tied to that definition in Title 17. And of course, this is, short-term rental ordinances are not even in Title 17 anymore. So primary residence just really helps you focus on like, where is their primary residence? Where do they primarily reside? So it helps you get sort of untethered from that definition in the other title.
Quick reminder, Nashville Network just told me that this is still being recorded to broadcast, and so if you speak, please activate your microphone.
All right. The zoning administrator can deny owner-occupied permits on the basis of documents and affidavits from neighbors regarding residency. That's new language. The zoning administrator can require additional documentation if the primary residence is in question. See, next slide. There's that change in the language that people are using, the documents people have to submit in order to get the owner-occupied permit. So we have two different groups. Group A is you can submit two from this group: a driver's license, a Tennessee ID, voter registration, IRS tax reporting form, current car registration or title. So you have to have two from that group, and two from Group B, which include current car insurance, life insurance, homeowner's insurance, paycheck or check stub, bank statement, employer verification or letter, but not if you are self-employed. And that's a big change. And if the zoning administrator determines there's been a change in ownership, they must apply for a new SDR permit under the current ordinance. So all that is new language as of last year, end of last year. Okay, I just kind of threw that in the middle of the ethics training just to let you know, because after all, you are supposed to be making these determinations based on the current law, and that is now the current law. All right, goal number 5, and this is important, understanding how the Public Records Act works. It makes your emails and your texts regarding commission business open to the public, and the Open Meetings Act prohibits deliberations outside of board and commission meetings. So public record is pretty broadly defined here as all documents, papers, letters, sound recordings made or received in connection with the transaction of official business by any government entity. So any communications discussing board business. It doesn't matter if we're talking about a private email address or a metro email address. So if text messages are on your private phone or a work phone, they are all public record, and we can ask for them if someone submits a public records request for them. So I actually often recommend that, you just set up a new email account, like a new Gmail account, whatever, for your Metro business. And that way it's really clean and it keeps it separate. I know sometimes it's hard to remember to check those emails, but I don't know. I think it's a good idea to just keep it really separate, just in case there were ever a request. You wouldn't have to go through your personal email or work email and dig up those emails. So that's what I would do. All right. Deliberations must take place at the board meeting. So you should avoid the use of email or text to discuss board issues or invite comments from other members concerning any public business. Please don't do this. Don't reply all to emails sent by staff to board members. If you have questions, direct them just to staff. If there's a violation of the Open Meetings Act, then the decisions based upon those kinds of deliberations could render those decisions could be rendered void. The judge could also order court supervision of a board, and this did happen in the past when there were private communications, like emails among commission members prior to a decision being made, and that decision was voided. Okay, what is a meeting? Sometimes it's kind of hard to know, but actually it's really just two or more people who are members of a governing body who have the authority to make decisions or recommendations to a public body if they meet and make a decision or deliberate towards a decision. So you can meet at Kroger and talk about the weather or the Titans or whatever you want, but just don't talk about business that is coming before this board. So it's really about that making a decision or deliberation towards a decision. That's what makes the meeting click into gear. So for our meetings, we always have to have adequate public notice so people can attend and be heard. If they're basically the definition of adequate public notice, it's a little squishy, but basically sufficient notice under the circumstances that would fairly inform the public of the meeting. And generally, we like to see all the notices posted about 5 days before any given meeting. And of course, under the Metro Code, there's also a requirement that there be adequate notice posted on the ITS for the Metro website. Okay, what is not a meeting? So, for instance, you can go and do an on-site inspection, but if you see someone else there from the board, you can't talk to them about the site. The chance meeting, that's the Kroger. Attorney-client meetings is the other exception. If there is pending litigation regarding this board, there can be an executive session where someone from Metro Legal would come and discuss with you that pending litigation, and basically it would be an information session. They could give you information, answer questions, but then any decision actually made about how to respond to that litigation would also have to be made within the context of an open meeting and a public meeting. But that information session could be closed. All right. Best practices for making informed decisions. You got a really great staff here. They work really hard from you. They come prepared. They give you these great, long, really detailed packets. So that's terrific. You have a detailed agenda for each meeting. They give it to you in plenty of time. So I think you come in here with a lot of information, very informed. They do a staff report, right? They include that in the packet, so that's really great. I mentioned here that you can start each meeting with a declaration about conflicts or recusals. You can also do that just before individual cases if you want to. Sometimes it's easier because people forget and lose track. All right, and just, as a board member, make sure you understand the work of the department. If you have questions, ask staff. They are here to help you. They do a great job, especially if you're newer. It's always good to kind of get a sense of how things work around here. Who are the inspectors? How do they go out and do their job? What's their process? Feel free to come and, right, Mac, you'll take questions anytime? Oh, sure. Yeah, of course. And just come to the meetings prepared, ready to discuss. We say consider adopting metrics to measure things. I don't know if that's necessarily pertinent to your board, but that's something people sometimes do, but I think that's not necessarily
We're going to kick people off the island if we don't meet the metrics.
Yeah, that's right. We're not going to worry too much about that, but that was the short and dirty version of this. I tried to keep it very quick. I know you guys had a long afternoon. Thank you for bearing with me. Always feel free to ask questions, and thank you. All right, we're good. All right, yes.
Okay, and with that, I have no gavel, but we are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.